I want to get to item 10.
I know, right? Item 10.
Well, you have some control over that, so.
So do you?
Yeah, so do I, so do all.
We all do.
We all do.
20%.
The fun is best.
What's that?
The fun is best.
So, I get a message from my daughter. Mom, I'm having the worst back cramps today. I hope I don't go into labor while you're in a meeting.
Oh,
I'm out of here if that happens.
yeah.
Okay.
Yeah.
All right. Good morning. I'd like to welcome you to the Planning Commission meeting of September 22nd, 2016. Let the record show all of the commissioners are here. Would you join me now with a salute to the flag? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. Are there any agenda changes today?
No, they're not.
Okay, next is our public comment period. If there's someone with us that would like to address the Planning Commission on a land use item that is not on our agenda this morning, this would be your opportunity. Okay, seeing no one. Next is the consent agenda, which is the approval of the minutes from August 18th and approval of the minutes from August 25th. Are there any revisions, corrections?
There were some typos and corrections. I can give them to you quickly if you want.
Okay, great.
August 18th, third page, top of the page, Gray Meyer, should be Greg Mayer, M-A-Y-E-R.
Okay.
Down near the bottom of that page, under section H, reports, the reference to PF 2.-16 is not correct. It should be 2.6.
Noted.
And that's it for that one. And then on the minutes for August 25th, the only suggestion is on page 3, under public comment, the first name is just Silvera. It should be David Silvera.
He'd probably like that.
And that's all the suggestions I have.
All right, with those amendments, is there a motion to approve the minutes?
So moved.
Second.
It's been moved and seconded by Lisa. All in favor, say aye. Aye. Motion carries. Okay, next up is, and I will just say that we have 10 items on our agenda today, so we're really going to be very cognizant of time. And if you're speaking as someone else has spoke before you, that basically is you're repeating either support or rejection of what they said, you could just please say that. We don't need to hear every comment multiple times. So out of respect for everybody's time this morning, we're going to try and keep a tight schedule. So our first public hearing is 2016-1039, appeal of rejection of commercial cannabis cultivation registration applicants for APN 050-066-002 and 050-066-006.
Good morning.
I'm sorry, we'll be getting to you. Okay. I think we're gonna hear from staff first. Thank you.
Dawn, her mic's not working. We need to try to...
Yours isn't? No. Oh, all right. We have no, okay. Whoa, that part's working.
No, it's never going to.
I have a loud voice, so... Good morning, Darcy Gallart with the Planning Department. Before you today is an appeal of the Planning Director's rejection of to submit 2 commercial cannabis registrations. The reasoning was that there was a lack of evidence to support the appellant's claim that he did in fact submit 2 applications on the closing period, which was June 30th. A little bit of background, just to sort of understand the process, is that leading up to the deadline, staff was taking in about 80 registrations a day. That does not include those folks that didn't meet those minimum requirements that we sat down with but had to turn away for that day. So on average, about 80 per day. That last week, we saw a huge rush of folks coming in. So what we started to do was have a sign-up sheet so that we could take folks in the order that they came in, close for lunch, start back at that sign-up sheet. So we also realized that there was no way we were going to get through the 300 plus people still left on that list on the final day. So we came up with a process to handle that high volume to ensure that everybody that did want to submit their registration application by 4 p.m. on the 30th could do so. What that process was is that we created something called a notice of receipt of application. And this was a form that when somebody came in on the 30th, they would hand us their registration packet. We did not review it. We did not take any money. All that we did was take in their application, put it in a folder. We filled out a notice of receipt of application, which basically put their name, their address, and a copy of that was included in your packet. We would date stamp that notice that we provided to them, and then we informed them that they would receive a call from us to come back in within the following week to actually sit down and go through their registration application to make sure that they had everything in there. If it was acceptable, we would then take their money. Those documents were then placed in a file folder and placed in a box so that we could continue to take those that came in. So again, we did not actually on the final day look through applications, process anything, take any money. This was a way that we could get through everybody in a timely manner on that last day. So a couple weeks after that closing day, I don't have an exact date, so I do apologize. The appellant called and claimed that he did submit 2 applications on that final day, but he was not provided any sort of a receipt. So he was informed that staff did provide everybody a receipt on that final day, and we actually had several hundred printed off so that we would not run out. The other thing that their letter claims is that possibly there was a clerical error and the files were misplaced. So I'm going to talk a little more in detail about that further on in the presentation. So in terms of the responses, I'm not going to go over it again, so I just explained it. We did provide everybody with that notice of receipt of application on that final day. It was date stamped. It had the basic information from that registrant on that form. In terms of the clerical error, we did take in probably close to 300 on that final day. And as I had explained, the process were placed in a folder, put in a box right next to staff. Those files were kept in a secure area that is only accessible by staff. So once those doors locked, you had to have your fob specially coded to get in that room. And the appellant of the 1,000 plus we've taken today is the only person to make a claim that staff did misplace their files. What we did find out through the process in speaking back and forth with the attorney and the planning director is that we did find that the applicant submitted 2 notices of intent to cultivate on June 30th for the 2 addresses, 140 and 147 Milshire. And what a notice of intent does is it basically states that I said, whoever it may be, intend to cultivate in the future on a particular piece of property. Folks could have submitted that because maybe they couldn't meet the requirements in the urgency ordinance, the May 10th deadline, or maybe they just wanted to hold their spot to cultivate in the future. So we did find 2 notices of intent, which those particular documents, when we took them in, we date stamped them, we put them in a folder, and we file them away. We do not hand out receipts for those, but if somebody did request a copy of their date stamped letter, we did provide that to them.
Can I ask a quick question, Darcy? Was the notice of intent signed by the appellant on that last final day?
I believe so.
Okay.
Yes. So just to get into a little bit of detail. So what I did when we received the appeal is that the applicant included 2 copies of what he stated he did submit to us. So I kind of went through that to see if they were to be submitted, what would be compliance issues, would he complied or not. So I'm just going to briefly go through that. These properties are adjacent to each other, 140 and 147 Melcher Lane. I did notice a few issues with the applications, which I will also talk in a little more detail. For 140 Melcher Lane, there's some discrepancies in terms of the spelling of the owner's first name. Some of the documentation we have spells it S-H-A-W-N, and that comes from county records and a recorded county deed. The documents in the file all spell the name S-E-A-N. Some Google images that were provided in that packet for 140 Melcher had some dates that were blacked out. One of those photos did not have a date blacked out, and the date on that would have been after the registration period. The photos that were submitted lacked date stamps, and they appeared to correspond with activity on that adjacent parcel. In terms of 147 Melcher Lane, there are 2 listed property owners, Jeffrey and Tina Souza. Only Tina Souza signed the documentation that's in the file. And also in this case, we do have issues with the spelling of the last name. County records spell the name S-O-U-Z-A. All documentation and signatures in the file are S-U-Z-A. So if, for some reason, if the appeal were to be granted, these are issues that would have to be resolved immediately in order for us to continue processing. So in terms of the spelling of the name, what we found was that in the right-hand corner, you'll see the recorded deed shows the spelling, the legal spelling of the owner's name, S-H-A-W-N. All of the information that we see on the documents is a different spelling. So the discrepancies in the spelling of the name and how the signatures are throughout the documents will have to be resolved if we do move forward. Here's one of the Google images provided in there, and as you can see in the top right-hand corner, it was blacked out. The final Google image that's in the registration packet that the applicant claims was submitted has a date of August 14th, which would have been after the close of the registration period. In terms of the other property and the last name, county records have the S-O-U-Z-A spelling. Everything in the file, there's a few documents that go back and forth between the spellings of the last name. Some of it is hard to determine because it's a scribbled signature. So again, this discrepancy would have to be resolved. In terms of CEQA, CEQA does not apply to projects which a public agency rejects or disapproves, so we did not do CEQA on this. And at this time, staff is requesting that the Planning Commission pass a motion to sign a resolution to deny the appeal. I can answer any questions you have.
Any questions for Darcy?
Yeah, one. Have you conducted a search for the registration applications for Santos?
Yes, we've conducted a search, and to date, every application that we have has been entered into the system. It has been touched a few times and refiled and reviewed, so we have not located the 2 registration packets that he claims were submitted.
Thank you.
Any other questions for Darcy?
The letter of intent that's submitted, was that something that was common and was going to allow people to file later? The deadline was drop dead June 30th.
So there was the provision in the urgency ordinance. Peter, do you want to answer? Or?
Sure. So the understanding that the intent of the ordinance was to allow those who were cultivating as of May 10th or had prepared the site could continue to cultivate. And then as we were working towards a new permanent ordinance, there was a window that could be open should we adopt a permanent ordinance that would allow new registrants to apply and get a permit to grow. And so that notice of intent process was to sort of get people in line for those who didn't qualify on May 10th to grow, but wanted to grow in the future. But that's all subject to the passage of a permanent ordinance that would allow new cultivation to occur.
Okay. Any other questions of Darcy right now? No? Okay, so would the, imagine you're the appellate's agent?
Yes, I am.
Okay.
Good morning. My name is Ashley Bargainquest. I'm here for Mr. Santos, who's also here. Basically, at no fault to the planning department's hard work, we believe that Mr. Santos's registrations were simply misplaced. They had an incredible amount to process. I was on the phone with the planning department and Mr. Mauer several times during that week and the weeks leading up to the acceptance of these registrations. And to my understanding, I don't believe that Mr. Santos is the only one who believes his registration was misplaced. I don't know if no one else has filed a formal appeal for this process, but in his communications with other members of the cultivation community, he has heard of other complaints of this. And I know that other individuals have discussed not having received these receipts that were available that day. Our contention is that Mr. Santos worked very hard on these applications. He went to great personal expense in time and in funds. He has all of his notarized documents and had prepared these documents for a June 30th submission. We also know that Mr. Santos was in the appropriate location on the appropriate date because there are submitted notice of intents. These notice of intents were prepared by Mr. Santos that day at the location at the advice of another individual there saying that he should do it. He was a little confused as he had been providing an entire registration rather than just a notice of intent, but filled them out and filed it. Last, it is just that he, having had these documents already prepared and having had been in the correct place at the correct time, to me, and I hope to you, it seems logical that he would have at least submitted an incomplete registration document. The fact that there is no record of this registration at all, again, I want to reiterate, I believe is no fault of the planning department. They simply were inundated with a lot of registrations. To address some of the issues that were brought up, first, the spelling errors of the names of the property owners. I can understand that that would bring up an issue if perhaps this wasn't actually signed or notarized, but all three landowners would be willing to attest that they did sign this, these were these signatures. We have the notarized statements, not the originals as those were submitted and are MIA, but we could re-notarized documents to assure that these were not fraudulently obtained nor fraudulent signatures. Second, the Google image that comes from 8/14/16, that is a Google map that was prepared for this appeal, not initially, because he did not have a copy of the plot plan that had been submitted. So he prepared one to have the full copy. Finally, the photos are of the corresponding different plots about what was happening. Mr. Santos has, since this appeal has been filed and since the registration was attempted to be filed, has removed cultivation from one of those plots entirely in order to avoid abatement fines, which will be, as you know, accruing throughout this process. Again, I'd just like to reiterate, there is a lot of work that went into these registration packets, as anyone who filled one out can tell you, and I'm sure that the planning department could also tell you. He had these registration packets prepared before this date, was in the correct location to file these on that date, and it is simply, I don't believe that it is an insult to the planning department, nor is it meant to be to insinuate that perhaps 2 packets had been lost. If only 2 of these 300 applications were lost, I think that is something to be commended, but I do not think that Mr. Santos should be punished for it. Are there any questions?
Any question? I'm sorry, it was Ashley
Bargain Quest.
Bargain Quest.
I can spell it if you'd
No,
like.
that's all right. I just want to get it right. Bargain Quest.
Sign in, that would be great. please.
Yes, signing in would be, thank you, Annette. She'd really appreciate that too, Bargain Quest. So you will sign in, but are there any questions Ms. Bardenquist?
Can you bring the grant deed back up again, please? So my question is that this is a notarized document with Sean Myers' signature, and then we also have an acknowledgement with a notarized signature, and I'm just having a hard time comprehending how the name could be spelled differently when a notarized document has to provide ID with correct spelling before it could be notarized, and legally has to have the proper spelling. So the acknowledgement is a little bit of an issue for me, being that his signature doesn't even look like that, and you would have to have ID on the spelling of that name, so it's kind of weird.
I mean, I don't disagree that this is kind of strange. I have a copy of the acknowledgement here that was submitted with the documentation, and it has this notary public stamp. I was not present when this was signed. I'm not sure why Ms. Saria Embriz, who is the notary on this, didn't check that.
As far as,
No, I'm sorry, if you're going to, could you finish? And if you need to speak, then you need to come to the microphone.
Because it says personally appeared Sean Myers.
that's as far
Could
as
you please state your name for the record?
Steve Santos, I've been leasing the house from him, and from every signature that I've ever got him, that's his name he's given to me, and that's when we went to notarize, he showed him their ID, and that's the signature that he presented.
It doesn't even look like that signature.
I mean,
That it is a concern, and I would be glad to follow up with Ms. Embriz about it. I mean, it's a notarized signature, and I'm not sure why they don't match, to be perfectly honest, but we would be able to have Mr. Sean Myers come in and say, like, yes, that's me, if that was an issue with accepting the application in the future.
Any other questions?
Yes. Did I hear correctly that Mr. Santos has removed cultivation from one of the sites?
Yes, he has, simply because the fines that accrue in the event that his registrations are not accepted are too high, so he has removed them from one of the sites.
So which site did he remove them from?
147. 147.
Which is Souza?
Oh, that's Myers.
Now, does
Mr.
that
Sean
mean
Myers.
he's no longer pursuing a registration for 147?
He is pursuing a registration. He has removed cultivation from that and would like to continue to do it in the future, but could not afford in the instance that the board did not grant his registration to pay those fees, and so responsibly removed and abated that in the meantime.
So his residence is on Myers and the grow is on Souza's.
Correct.
I think you made a comment that Mr. Santos may have been confused regarding the notice of intent as contrasted with the registration application.
Yes.
So then is it possible that when he submitted the notice of intent, he thought he was submitting a registration application?
I suppose anything is possible. However, having spoken to Mr. Santos about it, he submitted the packet that he had worked on, not the single sheet of documentation. And that packet is not present in planning department files.
Well, we know he submitted a notice of intent, correct?
Yes. I had not been informed during my initial communications with the planning department that a notice of intent had been filed. Initially, when I asked whether or not either of these parcels had anything registered to them, I was told by multiple individuals that no, there's nothing, no, there's nothing, no, there's nothing. And then Mr. Santos said, well, I do have pictures of a notice of intent, and I provided, I brought these up, and then was informed by the planning department that in fact, oh, yes, we do have those. So I completely understand with this much documentation, it's difficult to keep track of all of it. I believe that's an example of how Mr. Santos's paperwork has been difficult to pin down.
If you look at the registration application on 140 Melcher, the handwriting for the signatures of Mr. Santos and Mr. Myers look similar. Do they look similar to you?
The writing of Sean Myers and Steve Santos, the print looks similar. I wouldn't say the signatures are, I'm no handwriting expert, though.
Well, I'm not either, but they do look similar to me. There is and again, I'm on 140 Melcher.
Okay.
There is a medical cannabis cultivation landowner consent form that, by its terms, requires a notarization, and I do not seem to have a notarization for that form in my packet. Is there one?
There is the notarize, the problem is we can only submit a copy to you, a copy that Mr. Santos kept. The notarization that appears in the packet is for both of those documents, and both documents had the seal, the punch seal on each of the pages to show that they were part of that notarization. However, that is not reflected in the copies, as it doesn't copy, that imprint doesn't copy.
So you're saying there was one notarization for two separate signatures on two
Yes.
separate documents?
To my understanding, that was how Mr. Santos's notarization occurred. That was how he was directed by the notary. He trusted the notary to tell him how this was properly done.
Again, on 140 Melcher, I didn't find any date-stamped photographic evidence of grading or cultivation prior to May 10th of this year, and the planning department pointed out the same thing. Do you have any such evidence?
We have, these photographs, I suppose we'd need one more page showing the iPhone screenshot, if you would, that puts the dates on them. There isn't date stamps on these. We could provide that.
Okay, on 147 Melcher Lane, what is the right spelling of the landowner? Is it S-O-U-Z-A?
S-O-U-Z-A.
And so what is the explanation for some of these signatures being spelled S-U-Z-A?
Honestly, I do not know. When I pointed it out to Mr. Santos, he also did not know why that was not, where the O was excluded.
If you look at the signatures of Mr. Santos for the registrations on 140 and compare it to 147, they don't look similar to me. Do they look similar to you?
Excuse me, I'm finding signatures on both pages. There does seem to be more flourish on 147, but I believe that, again, I'm not a handwriting expert, but Mr. Santos would certainly be willing to testify, I suppose, to the board that these are indeed his signatures.
Again, on 147, my packet doesn't seem to contain a notarization for the indemnification agreement.
Again, this is Ms. Ambriz, and Mr. Santos simply followed her directions as a notary public on how to continue this. Similarly to 140, the pages should be indented, but that does not reflect in copies of the documentation.
Thank you.
To follow up on the, you had a timestamp picture of the notice of intent on the day that supposedly the applications were turned in. And, but there was no picture of the applications that you had in hand at the same time, only the notice of intent when you walked in.
So why are there not pictures of the
Applications.
registrations? He didn't take a picture of the stamp on those registrations. In the photographs, I didn't bring it up because it's impossible to actually show what other documentation is there, but documentation is sitting on top of other documentation. He doesn't have the picture of the top because the receipts that he did not receive that day, he assumed he would get later. Of course, now hindsight is 20/20. I'm sure Mr. Santos will take pictures of everything that he files in the future.
Documentation is crucial. Also, I'd like to follow up with, here on the registration applications, these were copies made prior to him going in and putting the rest, turning the rest in on June 30th?
These are kind of Frankenstein copies, to be perfectly honest. Some of it is copies of what he had. Some of it is copies of the originals that he had presented copies of. Thus why the Google document for 140 Melcher has the date of 8/14, as he did not take a copy of that before he submitted it.
Okay, here on Steven Santos declaration number 4, well, coming on from number 3, he says, the individual at the counter was a male. He looked at all the paperwork, informed me that I was missing a copy of my government-issued ID, but that copy machines were available for use. He also told me that I should file a letter of intent to cultivate to ensure future licensing. Then you move on to number 4 here. It says, I then got outline and made 2 copies of my driver's license, one for each registration application.
Yes.
So if you turn those in for one for each registration application, how is this one included in with the copies from prior on the registration applications? Or was that one made
That's
after
part of
and
the
inserted?
Frankensteining, yes.
Thank you.
So he says that he's lived on this property for a couple of years, is that correct? No? Oh, I thought you just said that.
Could you wait till you get to the microphone and then
You have
please
to-
state your name for the
I
record?
just started,
This
Steve
is-
Santos, and I
Thank you.
just started renting the property this year.
Okay, because I was going to say the lease started on April.
Yes,
Okay. And that's when you started planting the grow?
yes. We were already growing across the street at the other property
Okay,
before then, yeah.
okay.
Any other questions right now? No?
Madam Chair, I have a question.
Yes.
If I could. You'd indicated that the notice of intent he filed at here the day that he was submitting because he thought it was a good idea. Were the owners with him at that time?
No, he was submitting
So
it.
how did we get the signatures of the owners on that document if you just filled it out the day that he was here?
Were they- This
The
one.
no- the notice of
Could you please
intent?
come to the microphone?
So the notice of intent has picture, or has the photo, the signatures of the 2 landowners
Did you,
for both of these.
were they there?
But
She works in town, and I
Oh.
ran that over for her to get signed.
Tina's
They both
was, but
work
what
in
about
town.
Sean?
They both work in
Oh.
town.
They work in town.
So you ran over and got their signatures and then came back and submitted?
Yes, that was filled out here, yes.
Okay, thank you.
I think that's all the questions we have at the moment, but we may have more,
Would you like me to put both my name and Mr. Santos's name on the sign-in?
unless he wants to put his name there himself.
Well, either way. Do you want
Okay.
them both there?
We would.
Thank you.
Is there anyone that's with us this morning that would like to address the Planning Commission regarding this appeal? If you could come to the microphone.
My name's Chris Irvine. I just have a question. He stated that he removed the product from one of the sites. That is a controlled substance, need hazmat permits and everything. I was wondering if those were provided or if it was sold.
I have no idea about any of those issues about how you remove marijuana plants and what happens to them. Anyone else? Okay. The appellant has another opportunity, and anything you want to add?
Only that anyone, if you take a look at these registrations, the dates on these documents show that this was prepared previous to June 30th, albeit except for that Google document. And knowing that Mr. Santos was in the correct place on that date by his notice of intents, I would ask that you find that his registration at least be allowed to be considered. Any further issues with it, we'd be glad to resolve with the planning department. But the consideration, despite it having been misplaced, would be greatly appreciated.
Thank you.
Thank you.
All right, so deliberation by the Planning Commission.
I have a question. That is, if we were to find that for some reason the paperwork got messed up and confused, and there was a lot of confusion because of names and all that, which shouldn't happen, but it appears that maybe it did happen, what window does that open for them? Or what does it close them off? Or what's their status?
So are you saying if either you decide or we discover that, oh, here is the file, the missing files, that they suddenly appear, what would their status be?
Yeah.
Well, we would then put them in process, and we would be reviewing the file more thoroughly. We would continue the review process that we have for all of the registrants of site inspections and review the documents to determine whether or not they qualify, and then either approve or reject the registration.
How did we discover that his registrations weren't there?
We did a search through the boxes, through the files.
But did he call you and say you haven't contacted me?
He called and
contacted
said, and I actually was the person who spoke to Mr. Santos first.
Okay.
And he called and said that he hadn't heard. He submitted 2 applications. At that point, we were, had already created lists for people to come in, appointment dates. So I started looking through the list and I didn't see his name. So we just started looking through boxes and trying to locate files. I informed Mr. Santos that if he did in fact submit those on the final day, that he would have received that notice of application receipt, as we did provide them to everyone. At that time, if I recall, he had only mentioned 1. Somebody called back shortly later and spoke with another planner. And then there were 2 registration applications that were now missing. And then shortly that same day, I believe, is the first phone conversation between Peter and the attorney.
Discussion, what would you, what's your,
Well, I'll lead off. Number one, the original registration application has never been found. And one would think if it was submitted, it would show up someplace in the planning department office. Second, there is no notice of receipt that Mr. Santos has, both of which would seem to indicate that the registration applications were not submitted. Third, it is, of course, anything's possible, but in this situation, maybe it's probable, but there was some confusion between the notice of intent and the registration applications, and he submitted one but not the other. There are too many discrepancies here in the application as submitted. In any event, there is no photographic evidence of cultivation or grading on 140 Melcher prior to May 10th. And the applications have to be complete under the ordinance. And apparently a true and correct copy of the original registration wasn't kept because we have a kind of a Frankenstein situation here, which makes it very difficult to say that the application, if one was submitted, was ever complete. So my inclination is to uphold the planning department's rejection.
I also find too many inconsistencies with the signatures provided. The Frankenstein put together of the registration application and things added post, and just through my experience and working through everything, documentation is crucial, and if there's receipts to be had when you turn in a registration, I would make sure you would have them prior to leaving.
Based on the ordinance, it does state we have to have complete applications at the time. We don't have a complete application in front of us to rule on. We have a letter of intent. Looking for clarity on that letter of intent, it was for down the road, if it were to open registration back up. So I don't believe the application was complete. I have very serious concerns about the signatures on the acknowledgements and the notaries. I'm going to uphold the recommendation from the planning department. And I would suggest that if he's going to appeal this to the supervisors, he might want to consider having people come in and verify their signatures.
Yeah, I tend to agree, except that if they do appeal it to the Board of Supervisors, which is certainly their privilege, I'd get people together that could appear, that would agree on what their name is and how to spell it. So that's what gives me a little hesitation, is the fact that there's just a lot of unusual things going on here. So I'm inclined to go along with the recommendation.
I am as well, especially I think Commissioner Worcester summarized his points very well about not having the original application, the potential confusion with the notice of receipt. I too am troubled by all of the discrepancies, and for that reason too, I would uphold the planning director's recommendation for denial. So is there a motion?
I'll make a motion to uphold the planning commissioner's recommendation for denial on 2016-1039, and yes.
There's a motion. Is there a second?
Second?
It's been moved in second. All in favor, say aye.
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 Thank you very much.
Thank you for your time.
Thank you.
For the record, the action today is appealable within 15 calendar days from today's date.
Okay, next we have 2016-1054 appeal of planning director's denial of commercial cannabis cultivation registration, application 2016-392 for APN 010-021-065. Darcy?
Good morning again. The applicant or appellant actually requested a continuance a few days ago. You folks received that continuance request via email. At this time, staff sees no reason to continue this item to a later date.
Darcy, was that on this item? I thought it was on,
It's because the number's wrong at the top.
The number's wrong at the top?
The application number's wrong at the top of the request. It's not the
so
same
it's
as
this
what's
one,
on
it's not on 1046.
no, it's 1054 and
Okay.
1064.
Okay.
I
It's
found
for,
out,
it should say it's for Daniel Jack.
Okay,
right, from Jennifer McGrath
Okay.
office.
Yes.
okay. This one? Okay, I'm sorry, continue.
So they requested a continuance. I believe the attorney could not make the meeting. At this point, staff doesn't see any reason to continue the request, but it is the planning commission's decision.
Okay, is there,
The
So first, you need to consider the
Right.
request for continuance.
so is there any discussion about the request for a continuance on this item?
It was not very clear why we would be requesting a continuance. The appellant is here, correct? Or stated in the letter they would be here?
I believe, he is here, but I believe the attorney couldn't be here, which was why the request was made.
Did we have, that was the only reason, was the attorney couldn't be here?
Do we know what the argument's going to be? Because it seems like this is just not the proper zoning
Yes,
under the ordinance, and that's kind of hard to quarrel with that, seems to me. So has anybody told you what the argument's going to be, where the lawyer going to show up?
No.
Do we know whether this Mr. Jack is cultivating now?
I believe he is cultivating now, but he can speak to that.
And I would like to know how many plants and when he expects to harvest.
So, I mean, I don't see any reason to continue this item. I think that it's fairly straightforward, and I don't see any evidence that would compel us to think that a continuance would provide us additional information that would lend to our decision-making.
Well, I tend to agree that it should not be continued.
Okay, so do we need a,
Well, you might want to hear from the applicant first to hear his reasons for
Sure,
a request for
okay.
continuance, then an action to approve or reject the request to continue would be
okay,
appropriate.
great. So are you, Mr. Jack?
Yes, ma'am. There's a few
I'm sorry,
discrepancies.
could you just please state your full name for
Yes,
the record
Daniel
and
Robert
sign in?
Jack.
Thank you.
Yes, ma'am. There is several discrepancies in the pre-ordinance prior to it being passed that had a list of approved zoning and disallowed zoning. Now, that didn't make it into the ordinance that was passed. Our zone was not addressed in either side, either denied or approved. And we felt that it would be approved due to the fact that timber production zoning is allowed to do agricultural, and all of the other zoning applicants, types of zoning were admissible into that type of zone. Another discrepancy is it's listed on one of these as
I'm
timber
sorry, Mr.
preserve.
Jack, could you speak a little more into the mic? I'm having a hard
sorry.
time hearing anything.
Sorry about that. There is a difference in zoning that I see. One is listed as timber preserve, and another says timber producing. So there's some confusion that we'd like time to address on what it really is zoned as. My counsel was unable to make it today due to the fact that we were only received notice on the 15th of this month, and she had other court arrangements.
So the zoning on the property is what, Darcy?
TP, timber preserve.
Right. So where are you getting the timber production?
I have several documents that list it differently, so.
Documents, county
We got
documents?
the Calaveras County Planning Department here for the appellant, the appeal, that says it's timber preserve. But we also have my escrow paperwork, which I actually don't have with me, that
So, but
lists it.
those aren't county documents, the
Okay,
escrow.
but here's the county document for the denial of improper zoning, and
Uh-huh.
it lists it at the bottom as timber production,
Ah.
TP. So there's two differences there that I believe are great differences.
I-
Not sure if they are, but they sound quite different to me. Production versus preserve.
Okay, so right now, we're basically trying to decide whether to allow a continuance. What is your reasoning for the continuance?
My counsel is unable to be here, who has the full argument.
Okay.
Any questions of Mr. Jack?
Under 17.9, we'll get to that under the hearing.
We'll consider your request for a continuance.
Okay.
Is there anyone else that wanted to address the planning commission on Mr. Jack's request for a continuance? Okay. So unless the urgency ordinance lists the allowable zones for cultivation occurs, it's not allowed.
That is correct.
Timber preserve is not allowed.
That is correct.
And timber production's not allowed.
That is correct.
So with that, is there, we need to rule on the request for a continuance. Is there,
A motion?
I don't want to do a continuance. I'd like to have the hearing today.
okay.
I'll second that motion.
All right, so it's an affirmative motion, and so it's been moved and seconded. All in favor, say aye.
All right.
Aye.
So we are going to be hearing your item today, Mr. Jack.
Okay.
Yes. So do you have further information since we're now hearing your appeal?
Nothing further than I have stated. My counsel would
Okay.
be the ones that have been paid to do that and is unable to be here. So.
Okay, thank you. And
Okay, so I do have a question for you. You were reading on your denial, we don't have a copy of that, as far as what you were reading at the bottom. What are you interpreting there that we should be looking at?
Just the fact that it's listed as two different zones, I'm not sure if the county is clear on what the zones qualify it to do as. I think possibly there might be two different zones, timber preserve and timber production, or I'm not even sure which one of those we are at this point because of the confusion.
Okay, when
And
you
how to
filled out
address
your
that.
registration application and you looked at 17.91 and you looked at the zones that were going to be allowed, did you see your zone on there?
No,
Okay, so at the time you applied for the registration, you knew your zone wasn't in 17.91?
so at the time we applied for the registration, I hadn't received the newest form of registration. There was some different ones being listed on the website, one of which had zones that were not going to be allowed and
Okay.
zones that were going to be allowed. We were in neither of those. And when we sat down, I have multiple applications, I had to sit down with Mr. Spear, and we actually discussed this, and he thought at the time it was reasonable to take our application fee and move forward because it wasn't clear to him how it would be dealt with due to the fact that there was not an address on that. There was a failure to address that zone prior to the ordinance being passed. So it was very early on in all of this, and I understand now there is language that does state if it's not addressed, then it's banned. So I do understand that's being said. I feel that that zone should have been addressed as one that's approved due to it being okay for agricultural production to happen on that zoning, is my understanding.
Okay, when did you apply for your registration?
Let me look at the date here. Oops.
June 24th.
Thank you.
So the ordinance was completed, voted on, and approved at that point in time
Yes, ma'am.
on the zones?
Yes,
Okay.
ma'am.
So you made the decision to go in and pay the fee. The planning department
Yes.
didn't recommend you do that?
Yeah, nothing to do to their
Okay,
negligence.
okay, got it. Unfortunately, I mean, this case is pretty easy for me to make a decision on because I have to vote what's on 17.91. The zones are clear of which it's going to be allowed in. I understand your appeal to that type of zoning. That's going to have to come from the supervisors at this point in time, so I don't have any further questions.
I'm gonna have to concur with Lisa, 'cause even if there's a discrepancy with you between timber protection and timber preserve, neither of those are listed here as an applicable land use designation for cultivation. So I'm gonna have to concur with her, everything else she said, and fall for that.
And before we go any further, was there anyone else with us today that wanted to address the commission on this appeal? Okay, seeing no one, we will continue.
Well, I agree with what's been said. The ordinance is fairly clear to me, specifying those zones in which cannabis cultivation is permitted, and the timber preserve or timber production zones are not there. And I think we encountered this same issue before and made the same decision.
Yeah, I agree as well, that it's clearly not an allowable zone for cannabis cultivation.
Not only that, but it appears that he knew that that was the case.
So is there a motion?
I'll make a motion to uphold the planning director's recommendation for denial.
Second?
So it's been moved in second. All in favor say aye.
Aye.
Okay, motion carries. Thank you.
Thank you for your time.
We're going to take a 5-minute break until 4 minutes after 10. We have to wait a few minutes. Some ladies, see, I'm good to my word here. Okay, so we are back in session, and our next appeal is 2016-1060, appeal of planning director's denial of commercial cannabis cultivation registration application 2016-112 for APN 048-011-021. Darcy?
Yes, good morning again. The appeal is the planning director's denial of a commercial cannabis registration. This application was denied due to lack of evidence to support the requested 22,000 square foot outdoor cultivation area for the subject property. Property is located at 2969 Highway 12 in Burson. It's approximately 30.8 acres in size. On the screen before you is the original site plan or plot plan, whatever you'd like to call it, that was submitted with the registration application. You see Highway 12 to the left, and the skinny part of the parcel that goes down. You'll see a 1.52 acre parcel where a house currently sits on. And then right below that is where the appellant had indicated the 22,000 square foot outdoor grow site is located. These were photos that were provided with the registration application. They are date stamped April 20th. It's hard to see on here, but it's the bottom right-hand corner down here is where the date stamp is located. So as you can see, there's several fabric pots with small plants, a green mesh fencing, some hay bales are shown over in this area. Some straw has been scattered throughout the site. And you'll also see some dry land. Here's some additional pictures that also have the same date, presumably just outside that meshing and some areas within. This is a April 16th Google Earth aerial image, April 16th of this year. And comparing the overall, this is where approximately where the site plan states that this grow was located. So just 4 days prior in this area, you don't see any cultivation. No pots, no plants, no green mesh fencing, nothing located in that area. And again, this is Google Earth image that is dated April 16th of this year. These photographs were date stamped April 20th of this year.
So this is 4 days prior?
4 days prior. The next aerial image you will see is a June 3rd aerial image that was flown by the county. Again, the location that was indicated in the registration packet as to where the grow site is. I will explain this area a little bit later. This is the 1.52 acre parcel where a house sits. So based upon what we saw in those April 20th photos, you would presume that you would be able to see some sort of a grow present on this site. If not in this location, somewhere else on the site. But unfortunately, we do not see that. Therefore, the planner that processed that did deny the registration application due to lack of evidence.
And that last photo was taken when?
June 3rd of this year.
Okay.
So we did receive an appeal, and what the appeal stated was that due to the proximity of the Men of Integrity halfway house on the adjacent parcel, that the registrant chose to relocate the grow site to another area. They provided a photo with a date of May 10th on it, and a revised site plan with that appeal, showing where they relocated that site to, which we'll look at next. This was the additional photo that was submitted. So as we can see, we see a bunch of little plants in pots on May 10th, actually May 9th is the date on this photo, with the building in the background. And I'll explain what that building may be in another slide. But as we see here, the photos that were submitted that were April 20th presumably show these plants in pots in the ground. However, now we've got plants in pots next to a building, so the information isn't matching up at this point. Here's the revised site plan that was submitted. So as we can see, Highway 12 would be up here. We have the house parcel here, and now the site has been moved from somewhere over here to somewhere over in this location. This was a revised site plan that was submitted with the appeal. This information was not submitted as part of the registration packet. So in terms of relocation of the site, this little blue square is approximately where they're stating that they relocated it. Again, this is that June 3rd aerial. In terms of the timing of when that was relocated, we do not know. That information was not provided. So bottom, original grow site, top, where they relocated it. In that appeal, there were also written statements that were provided. The first one from a contractor who stated he was hired to clean up the property. He was also hired to reinstall some corrugated panel fencing around the grow site. He states that he did witness the delivery of some topsoil in March and April. He also states that he saw plants next to the house, garage, and the breezeway. We received an employee statement. The employee states that he moved some plants and topsoil to the house to clean off organics and to clear for some fire lines. He also states that he removed a 6 foot perimeter fencing, which was constructed of corrugated panel fencing. So a couple concerns that we have with this is that the photographs do not show any sort of corrugated metal panel type fencing. We see this green mesh type fencing. There's no dates on that employee letter, so we're not quite sure when they stated they moved that. But what the ordinance does clearly say is that if you do have a grow site, you can move it, relocate it, if that portion of your grow site is within that 75-foot setback. There's no exceptions in there that allows you to move it because you think you're too close to a halfway house. Halfway house is not considered to be a sensitive use, so they don't have to meet that 1,000-foot buffer. So in terms of relocation of that grow site, just to be away from that halfway house, that likely is in conflict with what the urgency ordinance states in terms of being able to relocate your grow. As I said, no evidence in the older photos of that corrugated panel fencing. No indication from that employee of when the work was done. The other issue that is of concern is that if those plants were moved onto that 1.5 acre parcel next to the house, that parcel, number one, is not part of this registration, and number two, does not meet the minimum 2 acre requirement for a commercial grow. So they do not meet those urgency ordinance standards. And again, in that it's actually the May 10th photo that they submitted. It appears that that could potentially be the house or the garage that's on the property where those plants were relocated to. So again, as with other denials, CEQA does not apply to this particular process. And we are requesting that the Planning Commission uphold the Planning Director's denial of the cannabis cultivation registration. I can answer any questions you may have.
Any questions of Darcy?
Yes. Do any of the aerial photographs show any evidence of cultivation on this 30.86 acre site
Not that we have seen
at any time?
at any time.
And it is confirmed that the new proposed site that it was moved to is on a separate parcel that is...
What I believe, what they have claimed that they did during the process was they moved just plants and topsoil to that separate house parcel, but then their actual new, so this is the separate parcel where the house garage is contained. They've indicated that, well, the employee indicated in a written statement that he moved plants to somewhere near this house property. But the revised site plan indicates that this is their actual grow site.
So you had indicated when we were looking at the potted plants that you were going to go back to the building. What were you going to go back to on that?
Oh, so what I had indicated was that it appeared that, let me get back to that picture. Because you don't see the building, so you don't really know what it is. Mm-hmm. It could be the house that's on the property. It could be the garage that's on the property. The other issue is that these are now in separate pots. The previous photo shows them in larger fabric pots on the property. So there's no way to actually connect this photograph to this grow site. We don't have enough information in this photo.
The bigger pots, what date were those supposedly taken at?
April 20th is what these are all date stamped.
And then the other one was May 9th?
May 9th.
So they went down in size?
Potentially. The plant maybe not, the pot for sure.
Okay.
Well, the plant doesn't look different.
The plant looks about to be around the same size as those April 20th plants.
Any other questions of Darcy right now?
No.
Okay. Mr. Gomez, is the appellant here?
Yes.
Good morning, Chair McLaughlin, members of the commission. My name's Chris Williams. I'm just going to make some brief remarks on behalf of Mr. Gomez. He also is more familiar with the background facts, and we were not involved in preparation of his application. And because I was so successful last time I was here, I thought I'd come back.
Well, welcome.
I think there does need to be some consideration of an accommodation here. I know one of the major principles of the ordinance is that you want to be sure that the people that you're registering were cultivating before May 10th. And I think there's ample evidence that this individual was cultivating before May 10th. He actually formed a corporation for this purpose back in 2011, been paying taxes since then. And there was, with the pictures, there was no intent to mislead anyone. I think some people, when you're talking about the cultivation sites where you use smart pots, and all you have to show the commission at May 10th is just an empty field and then some potted plants somewhere. Now those potted plants may not be on the empty field. They may, I know one grower had all of their clones inside a barn. They were protecting them while they were young from the light, and that's where they were. That's still cultivation. They're tending, they have the plants, they're tending them. This particular applicant was growing at what you have there, the relocation of cultivation site. He was growing there in 2015. For some reason, he decided to site his application closer to the house where that is shown, the original location of cultivation site. Then they realized that they were within 600 feet of a men's halfway house. They thought that was a bad idea for more than one reason, but security was one reason. So the pictures they had of plants, some of them involved plants that were right up against the house. Some of them were plants from another location that they were going to put in the relocation site. And what I understand from talking to Mr. Gomez is actually the plants were being grown a little further to the east. They were under that tree canopy, so they couldn't be seen. I don't think you can even see the well that's there. I can't. But so the key here is that they were growing, they were cultivating. They did have plants, both at the house, which were not picked up by photography, probably still some plants in the old site. And, you know, they're seeking an accommodation in recognition that they were in the cultivation process when they started this. And it is at that relocated site, but it's always been going on at that relocated site as well. Ownership, I believe their father owns, there's two parcels in there. The big one that you see outlined in orange, and then there's a smaller one around the house. The lessor owner is the same person, and they have a lease of both parcels. So they had the necessary ownership or occupancy right to do what they did. That is all I have to say about it. I would like my client, Mr. Gomez, to explain further what happened.
Yes, good morning. Heriberto Gomez. I've been here in this county for 15 years. Probably know my face, but we've been cultivating there for the past probably 3 years in the bushes, small cultivation. And I'll be glad to take anybody up there to see what we've been doing there in the past 3 years and those bushes. But now that we're trying to comply with the laws that you guys are coming up with, so that's what we're trying to do. That's why we formed the corporation since 2011. But we're trying to comply, spend a lot of money. So anybody have any questions?
Yeah, how do you explain the fact that none of the aerial photos show evidence of cultivation on this parcel?
I know on that blue square there, there's a power pole. I can't see the power pole. There's a transformer of 200 amps there. There's a well there. You can't see that. There was 20 yards delivered there in April.
I'm sorry, what was?
20 yards of soil. You can't see those. I just don't understand how can you not see the well that's blue, or the power pole, or the soil. If you had a better photo of Google by the house on May 10th, you could see the plants were there. It's part of the same property. It's 30 acres.
There's 2 parcels on that property, correct?
There's 2 parcels, but it's 30 acres, and they wanted to be more than 2 acres. Why would you want to put the little plants out in the middle of nowhere where you can have close to the house, where the water and everything is at, close to the house?
Do you have a grow site somewhere off the 30.86 parcel? Completely separate?
What do you mean? Do we have another?
You have another growing operation that has nothing to do with this 30 acres?
Yes.
And the photographs dated April 20 that show the big fabric pots, was that taken at a different grow site off the 30 acres?
Yes. We had to move them because that was a light industrial zone that we found out that they would not take the check, so we had to remove them also.
And when did you move them?
We moved those when we rented a forklift. That was about $1,000 to move them. And we moved those after June, like after Father's Day, after like June 20th.
So as of May 10th, were the plants that are shown in the photographs dated April 20 on the 30-acre site or not?
There was plants on the 30-acre site, yes. Before May 10th, yes, there were plants.
But not
that big, not that big.
Not that big.
Yeah.
Okay, where's the photographs of the plants on the site as of May 10th?
The little ones were next to the house. The bigger ones were on a different site, like quarter of a mile from that site. They did not, they would not take our check because it was not a, what you call a, well, it's a light industrial.
Proper zone.
Yeah, proper zone.
Okay, so the plants shown on the May 9th photo are not the same plants as shown on the April 20 photo, is that correct?
Yes, yes. Those plants, a lot of those died too, because we grew a lot of plants because you do have a lot of them die. And we end up with about 120 right now, I think.
Okay. And is this, is your application for a 22,000 square foot permit?
Yeah, we did 22, but we end up surveying it, and it came out to be 14,000, something like that. We had it surveyed. We wanted to make sure we were in the proper area of our property lines, so we had it surveyed and had to pay $800 to have the property surveyed by a surveyor. And he surveyed it at that blue spot was like 14-something thousand. It didn't come out to be 22.
Okay, so the only photographic evidence that we have of plants on the 30-acre site is the May 9th photograph, correct?
That's pretty much it, yes.
Okay. And in your judgment, do those plants shown in that photo, will they occupy 22,000 or 14,000 square feet?
Yes,
Chair, if
because
I
it's not full. The whole box is not full.
Darcy?
If I could please clarify, the parcel that's outlined in the dashed red minus the parcel inside, there are two legal parcels here. There's a 1.52 acre parcel that the house sits on, and then the other parcel is the 30 acres that has been verified with county records. So this is not one legal parcel with two assessment numbers. It is two legal parcels, two completely separate parcel numbers.
So, and I'm confused. So right now is supposedly where the plants moved in closer proximity than the original cultivation site to the 1.5, are they now on the 1.5
From what
acre?
what I heard was that the plants in the May 9th photo were on the parcel where the house sits, which is the 1.52.
Is that
Correct
correct?
me if I'm wrong.
Yes, they were there, next to the house.
Okay. And you understand there's a problem with, it's against the urgency ordinance.
But in
to have-
February, we still had plants up there, a smaller grow up there, but you cannot see it there.
Where's up there?
Where that blue box is at, to the right, where those plants are at,
So it's really, you've moved 3 times?
there was two grows. The early grow in February,
Well, I'm talking about the application. So in the original application, is the red outline is where you said you were going to grow?
yes,
Okay. But then, since then, you relocated to the blue site? That was
Yes.
your next plan, but in reality, they're next to the house?
the plants are next to the house.
Okay.
Because you need to have a house on the property to accept the application, right?
Not for commercial grow, is that correct?
No.
No, and then
We
you
understand there had to be a house on the property. Maybe I was misled.
That's for a personal or caregiver grow.
Oh,
And that the urgency ordinance requires a minimum of 2 acres as a grow site?
if it's 2 acres, yes. That's why we have 30 acres. That's two kind of
But
parcels.
you don't, you're actually growing on a 1.5 acre site, correct, next to the house?
Not right now, no.
I thought you just said that's,
points you would.
Yes, we had plants there, but we also had plants also by those oak trees too. We have plants there by May 10th, and soil.
So for clarity purposes, we are only, the registration that's being denied is on the 30 acres, is that correct?
I think so.
That is
Okay,
correct.
so we're not even looking at the house site, that's not a part of your registration process, correct? You did not apply for registration on the 1.5 acres?
No.
So that doesn't matter. Whatever's happening at the house doesn't matter here today. The only thing that matters is what's happening on the 30 acres, because that's the registration you applied for, and that's what we have to make a decision on. Am I correct?
yes, that makes sense.
Okay. I was getting confused. Okay.
Any other questions on Mr. Gomez right now?
Not right now.
All right.
Madam Chair, I have a question.
Yes.
You'd indicated you were growing previously in the bushes.
Yes.
How much area were you growing?
It's pretty good, not that big, but I say 5,000 square feet.
Okay.
And there is evidence there to be walked through. You can see it.
Thank you. We may have further questions later.
Now, currently, you said you surveyed 14,000 square feet.
On top of the hill, yeah, we had to
Is
survey.
on top of the hill the house or the 30 acres?
The 30 acres,
So the survey in the 14,000 square feet is where you're growing currently on the 30 acres.
yes.
And that grow was started when?
On the top of the hill?
Yes.
Where we took the plants from one location to the other location, it was after Father's Day, like May 20th. I mean, June 20th.
Okay. So the grow was not happening before the May 10th deadline?
In essence, it was in the bushes, yes. There was plants there, yes.
Okay.
But you have a dated photo, May 9th of it on the other
parcel.
Yeah, that's on the other parcel.
Is there any photo of the plants growing in the bushes?
No, but you can clearly see it if you walk on the location. You can see it.
Okay, when you said you moved the plants because you discovered you were next to
Halfway house.
the halfway house, why did you do that?
We didn't want to put that location, like that red box.
Where's the halfway house on that map? Okay, so you were pretty far away from it.
It looks that it's far, but it's not far. No. They have a double-story house. You can see, like, it's real close.
Okay, so, oh, I see where your original location and you relocated. Got it.
Yes.
I see the, okay.
It's a big
I was looking at
difference.
it the wrong direction.
Big difference.
Okay, so did they ask you at the halfway house to move it and you did it out of courtesy or you just?
I did out of courtesy because it's better to, come out of their way of sight, yes.
Okay, thank you.
It's a lot better location, for sure.
And did you know that you were not authorized to move a grow location?
Was I told to not move it? No, I wasn't told I couldn't move
And
it.
the ordinance states that you cannot move the grow site unless you're within, what, 75 feet of a...
Within the 75-foot setback or within a 1,000-foot
Right,
sensitive
so it's
use.
not, I mean, there's one exception of when you can move a grow
Well, I
site.
can move it back to the red box. That's no problem.
Any other questions of Mr. Gomez right now? We're going to see if anyone else wants to.
Thank you.
Thank you very much. Is there anyone else with us that would like to address the Planning Commission on this appeal? Please come up to the microphone.
Morning, Commission. I'm Dennis Baskin. I'm one of the pastors at Glory Bound Fellowship, and you'll see where that red line goes up. That's our church just above the pond. And we have, I believe, in that sensitive area with our children and stuff. And the influence that would happen with a grow right there, I don't think is good for us. Now, here's the science behind what I'm going to tell you. I took a rangefinder and I went to the corner of the church and I shot across to the power pole that Mr. Gomez was talking about, which I can see from there. Then I went down to the youth center, which is that block wall that you can't see in this photo either, and took a shot. And then I came to the creek that you see idling down below the pond there. We still have some property on the other side of that, but we never allow our children to go over there because of snakes and just it's not good ground to put kids on. But they can circle the pond, they can fish the pond, they can do all the stuff they want. And I took some shots with that rangefinder and find out that I've got a 266-yard shot, and that's only a little under 800 feet. I've got a 162-yard shot from the youth center, that's 486 feet. And I've got a 137-yard shot, which is 411 feet, which would put me just about, well, where that creek is right there, and the same distance that the men of integrity would have been. So we're here in support of the denial that the planning department put forth. Thank you.
Thank you. Anyone else?
Can we just state in support of what you just said, just let it go at that, or do we need to do that?
Well, you could, so that you would be on the record. That would be fine, and if that's all, and that would be enough. Just say you support what Mr.
Okay. My name is Stan Logan, and I just want to speak in support of what Mr. Baskin just spoke, that the growth site is within that 1,000-foot distance of a sensitive use facility, and I stand in support of the denial.
Thank you.
I also would like to state my name is Robert Blind. I am one of the co-pastors at the church as well.
would like to support what Dennis had said. And to clarify that the reason that we were within that 1,000-foot sensitive area is because we do have youth-only events that we sponsor at our facility. We do have kids on the property, and that would be too close a location for the grow to take place, as according to the outline of what's in the urgency ordinance.
Thank you.
Good morning. My name is Michael Kudo. I'm here to support the denial. And for further reference, I'd like to ask the committee if I'm planning on building a home. So I was wondering if 3 years from now I can put in an application for construction, or do I have to do it before I start my construction?
I think you probably just need to talk to the planning director about that.
Good morning. My name is Mike Gonsman, and I'd like to support the last three people that came up to talk. And actually, I'm in the process of getting a gun permit. And I was just wondering if I could take my gun before I get the permit, too. I don't know if that's legal or not, but I thought I'd ask, so thank you.
Thank you. Anyone else?
My name is Janine Wisdom, and I am as well going to support Pastor Dennis and the denial. I am a parent at Glory Bound Fellowship, and as a parent, my concerns are great because my children attend there and attend events there, and so I am in support of what has been said as well.
My name is Georgia Mendoza, and I'm supporting all this group under the Pastor Dennis. I'm concerned. Nobody gets young. We all get old. I have one grandchild, which I waited for a long time. Now that I'm old, I can speak that it's really important for us to be example for our children. The children, not the money or whatever we think, because that is our future, and we have to be examples as grandparents and parents. And I'm also concerned of the word medical. I used to work for a hospital, and medical has nothing to do with applying for this kind of, marijuana is deeper than we think. Our children are very important to each one of us. Thank you.
Thank you.
Hi, my name is Martin Fute, and I am a member of Glory Bound Fellowship, and I am also a former resident at Men of Integrity House. And like them, my concern is for the children of our church. I am a helper with the youth facility, and being on that other side of the fence where, I used to use marijuana, I can tell you that it is not in the best interest of the youth at our church to be in close proximity to that. I believe it is not only morally and ethically wrong, but it is also, it doesn't promote any kind of positivity within our community to allow our children to be subject to that, whether indirectly or directly. So,
Thank you.
Hi, my name is Praline Yoakum, and I'm a realtor for Group B Real Estate, and I make it my career to look at properties. And I would like to say I've attended Glory Bound Church, and at no point in time have I ever noticed a marijuana grove next door. So I have a hard time believing that there ever was one. I think that there's a lot of money involved here, and it's a tragedy to see people willing to go to any length to get a grove. And I support the church, and I think it's a really bad idea to allow them to put a new grove in next door.
Thank you. Next.
Good morning, I'm Larry McMahon. With Glory Bound, I'm head of men's ministry there, and I just can't support them. I can support Dennis, I can support Glory Bound, but I cannot support a grow. Not when it's in 600 feet of what we've got going on there with the kids and everything else. It's ludicrous, basically. Would you want that next to your church?
Thank you.
Good morning. My name is Patrice Murphy. And earlier this week, my husband sent an email off to all of you, and he couldn't be here. So I just thought I would touch on it a little bit. I'm in complete agreement with my husband, and we are asking you to stand behind your original decision to deny registration of this cultivation. And in speaking more generally on this same subject, we would like to ask you to consider the over 700 registered growers we already have in this county. We need to put a stop to this out-of-control growth of cannabis cultivation in our county in all locations. I recognize that there is a wide spectrum of views in regards to this subject and do not wish to go into all the arguments against it at this time, but I do believe it defies all logic to think we need the volume of cultivation occurring in this county for commercial cannabis use. I ask you again to please stop the expansion of this growing problem in our county. Thank you for listening to me.
Thank you.
How many other members of the congregation are wanting to speak? So is it compelling a difference in testimony than what we've heard, just in the interest of kind of moving this along? Is it otherwise that, we'll, note that there are several of the members that support what's already been said? Is that okay? Okay. We've heard from you, ma'am.
I'm sorry.
We've already heard from you.
I don't go to this church. I don't go to the church. I think it's for myself.
Okay, thank you. Well, thanks for clarifying that. Is there anyone else that would like to
My name is Jean Fox. I'm also a realtor, and I'm also a resident of Burson, California. And I moved here in 1978 to flee the drug wars in Stockton. And now it would appear that some of our county leaders have decided to throw out the welcome mat to the drug cartels and the syndicates and bring in commercial marijuana grows. I'm very concerned about it being next to a church. I'm very concerned about it being next to the Men of Integrity house that's trying to undo the damage that's being done by the drugs in this world today. And as a broker, if I knowingly have a client, and I've been approached by clients from as far away as Florida, to do commercial grows, I tell them they're in the wrong place, that I will not participate. I would hope that everyone else would take such a stand, because I came here to have a quiet life. I did not want to have commercial marijuana grows around me and the murders and the crime.
Ms.
That
Fox, I
goes
don't
with
mean to
that.
interrupt, but could you focus on this particular
This
appeal?
particular property is next to the Men of Integrity. It is also next to a church. And I can attest, not as a member, but as someone who has been there many times and driven past when they were having youth activities, there are a lot of young people there between the ages of 3 or 4 years old and late teenagers. These kids don't need to be exposed to this.
Thank you. Is there anyone else? Mr. Mauer, you were going to provide some insight on the sensitive...
Yeah, the issue of sensitive use is defined in the county code in the, it's referred to in Chapter 1795, the Cultivation Urgency Ordinance, to the provisions of our dispensary ordinance. And a church by definition is not considered a sensitive use. There is some generalized language in the ordinance, and Darcy, if you could read that section.
Okay, so what we're looking at is 17.91B2, which states, not within 1,000 feet of a youth-oriented establishment characterized by either or both of the following: A, the establishment advertises in a manner that identifies the establishment as catering to or providing services primarily intended for minors, or B, the individuals who regularly patronize, congregate, or assemble at the establishment are predominantly minors.
So there's no question that minors, children are at the church site. I guess it's more of a judgment call as to whether or not you feel that this is the church is predominantly minors, and therefore would qualify under this provision. It's sort of a secondary issue in that that was not the reason that we denied the application, but if you felt that this qualified under that definition, then that could be additional findings for supporting the decision made by the planning department on this. There's another thing I'd like to point out. The ordinance states, and was intended to allow those people who were cultivating to continue to cultivate in the amount that they were cultivating as of or prior to May 10th. It does not allow people to expand their grow. So if Mr. Gomez was growing 5,000 square feet in the bushes, that's where he could continue to grow if he could document that and meet all the other criteria. It does not allow someone to move their grow site from one location to another or expand that grow site from what they were previously cultivating. And so in this case, the fact that he had cultivating plants on other parcels, the urgency ordinance does not give him the authority to move those onto this site and increase the amount of cultivation from what he was previously doing.
Any questions of Mr. Mauer?
No, but I have a question of Mr. Baskins, if that's okay.
Mr. Baskins?
the first gentleman to speak.
Okay.
Yes, sir.
Just for some clarification. You were pointing out the pond area that was used by the children, and you said there was a youth center.
Yes.
Is the youth center predominantly used by the children more than the adults?
Oh my, yes. It's designated.
Is the pond predominantly used by the children more so than the adults?
Most of the adults don't fish, but they go there to watch the children so they don't fall in if they're the little guys. So probably
It's
not.
predominantly used by
Yes,
the children
probably.
for
Sure.
fishing then?
Sure.
Okay.
We also, sir.
The youth center is predominantly used by the children, though.
Yes.
You can't say honestly.
Yes.
Thank you, sir.
The idea that we come with is
Mr.
strictly.
Baskin, I think that's, his question
Yeah,
was answered.
no,
That was
I'm
it?
sorry, I
Yeah.
don't want to cut you short, but
No.
we just addressed the question, please, right now.
I did.
And then we'll move forward from there. Thank you.
Thank you very
Appreciate
much.
it.
You're welcome.
So, Mr. Gomez, do you have any other testimony you'd like to present? You know, we're hearing the public comments or anything else, clarification you'd like to provide? No? No. Okay, all righty. Then I'll close the public hearing and bring it back to the commission for discussion and action.
Okay. It seems to be clear now that the April 20 photographs were not taken on this site. They were taken completely off the 30-acre site. The other photographs we have of May 9th were taken next to the house, which is also not on the site. And it's not part of this appeal. There was apparently a grow on the site in the bushes, but we have no photos of that at all. The ordinance requires that the registrant must provide evidence satisfactory to the planning director that not later than May 10th, 2016, he/she has taken demonstrable steps towards the development of a commercial medical cannabis cultivation site on the parcel, as demonstrated by the criteria described below. And one of those is date-stamped photographic evidence of cultivation commensurate with the area proposed to be cultivated. I do not think that any of these requirements have been met. And so I support the denial of the appeal.
I concur with Kelly. And for further questioning in the future, maybe consideration of what, let's say the youth center is predominantly used by the children, what parts of the property would that include? And if that would be part of it. I just want to bring that to public comment.
For me, it comes down to the 30-acre site where the grow should be taking place and a complete application. We should have been provided pictures of the existing grow in the bushes, trees, wherever it's at. I think moving it, considering that it was sensitive to the halfway house, was considerate. But when we're ruling on this, it's basically as the application was presented before the June 30th deadline. And none of these pictures are reflecting that application as we are to rule on it. So I'm going to uphold the Planning Commission's direction. Or direct department, excuse me. You should have caught me on that.
I tend to agree. I'm a little confused as to the legitimacy of this business of having musical plantations where you move them around. I think that's something there that's a little strange. And so I'm in favor of upholding the planning director's decision.
I agree. I don't see any evidence of cultivation at the authorized site. in the application. The urgency ordinance does clearly state that you're not allowed to relocate your grow from one part of your property to another unless for one particular exception. So there is no compliance with the terms of the urgency ordinance, and I would also add that, should this application be appealed to the board, that the inclusion of sensitive site receptors attended by minors be considered as part of this upholding of the planning director's decision.
I would suggest that the resolution be refined to make it clear, because it's now clear on this record that the photos that were submitted with the application were not of plants on the site. And that the later photos were also not of plants on the site. They were on the 1.5 acres, which doesn't qualify. And there was no evidence, photographic evidence, of any plants growing on the site prior to May 10th. And I would also include the finding regarding the sensitive use as an alternative ground for denial, because I think it's been established on the record that that's true. And also, there's a typo. At the bottom of paragraph 1 of the draft resolution, sentence reads, however, there is still no evidence that cultivation and/or grading earthwork occurred on the site prior to the May 10th, 2016 date.
Mine says site.
Mine says sit.
They got mine right.
So is there
Here's his.
a motion to approve the resolution as amended?
So
I'll make a motion as,
You need clarification?
I was just going to propose a sentence, just so that the planning commission has actual language to vote on. So as Mr. Commissioner Wooster suggested, I would recommend adding an E next to SIT in the last line of number 1 in the resolution, and add a sentence at the end saying, there was also no photographic evidence presented of the site sought to be registered, and the site is within, and the site is too close, the site to be registered is too close to a sensitive use. If that's the finding you're making.
is that close enough?
I think that's close enough.
Yeah. All
I
right.
concur with that, and I'll move to motion on the same text that Joel.
The amended resolution.
The amended resolution.
I'll second.
It's been moved in second. All in favor say aye.
Aye.
Motion carries. Thank you. So we are moving on to 2016-1055, appeal of 2016-337. Denial of commercial cannabis cultivation registration application for APN 040-024-010.
Before we begin, I
Yes.
would like to introduce the newest member of our
This
staff.
must be Miguel.
This is Miguel Contreras.
Welcome.
We're very happy to have him. He came on as an extra hire early on in the process, and we've recently hired him as a permanent staff member. So we're very pleased to have him with us, and I'd like to welcome Commissioner.
A little bit about Miguel, maybe, just a short.
He is a native, well, not native, but he's a resident of San Andreas, grew up here, recently graduated from Sacramento State with a degree in planning and geography with an emphasis on planning, and has been a tremendous help as we've been working through these applications.
Welcome.
Great. Welcome. Welcome, Miguel. So tell us about this appeal. And you might speak up a little bit and put the microphone closer to you. Oh, it's not working.
It is.
Oh. You've been scolded already.
Actually, this is an appeal of planning director to develop commercial cannabis registration. The applicant was denied initially because he was unable to produce evidence that no later than May 10th, he had taken demonstrable steps towards the development of a commercial medical cannabis cultivation as by the two criteria established in section 17.95, subsection N. And these two criteria are date stamp photographic evidence of grading or date stamp photographic evidence of cultivation. The subject property is a 6.96 acre parcel that is located 22 miles northwest of Joseph's Road on Western Creek Road in Mount Ranch. The photos provided initially by Mr. Bain, the appellant, are date stamped April 30th, 2016. Both photos that you provided depict at least 6 rows of pots. Soil filled pots actually, and all the both photos you can see at least 53 of these pots. However, on county imagery or aerial imagery acquired by the county that was taken on June 3rd, 2016, does not show any evidence of these photos or pots on the subject parcel. In his appeal letter, Mr. Bain shows concern that the county's imagery might be incorrect or it might not be post May 10th. Therefore, I have also provided a Google Earth image of the subject parcel. It is date stamped May 31st, 2016, and just as well, it doesn't show any evidence of grows or pots or any other cultivation on the parcel. Mr. Bain provided supplemental receipts to kind of show that he was in fact cultivating. And in terms of CEQA does not apply to projects with the post agency rejects or and staff recommendations to pass a motion to sign a resolution denying or upholding the planning director's denial of the cannabis registration application.
Any questions of Mr. Contreras?
No.
Okay, is Mr. Vang or Mr. Vang's agent here?
Michael Weisberg for Mr. Vang. Good morning.
Good morning.
All I can say is Mr. Vang has carried his burden by producing specific date-stamped photographic evidence. More than that, he can't do. You've seen that.
We saw the photographs of the plants, yes, that's what you're
Yes,
referring to.
that's right.
Yes, we have seen that.
More than that, he can't do.
So more than that, as far as evidence of something, of an aerial imagery, there's no evidence, and does Mr. Vang have some response to that?
All he has is what he has. He has the
Okay.
receipts for some of the items he bought
Right.
in the way of hardware to assist in the growing process,
Right.
and the date-stamped photo.
Right. So the only question I would say is that, receipts, purchase of materials, and photos of plants are transportable, or they're, it's not fixed to the ground, if you understand what I'm saying. As we've just heard, we've seen a lot of plants move around a lot of places. So evidence that those were actually on the site by the deadline, Mr. Vang doesn't have.
All he has is the photographs.
Gotcha.
And it's obvious from the photographs that that's the correct site. You can compare the other photographs that the commission's looking at, and you can see it's the same site.
Okay.
So he's clear in his own mind what he was doing on that date,
Okay.
and he supported it.
Great. Is there any questions of Mr. Weisberg?
The aerial imagery, and let's go on to include the Google map that he has up there. Would you agree that's the subject property?
I can't tell. I can't tell. If you ask me to agree, I can't, because I just
Mr.
can't tell
Vang's-
whether it is or not.
Mr. Vang's not here.
Mr. Vang is here.
Oh, maybe he could testify as to if this is the site. That might be helpful.
Do you believe that's the site?
And you please state your name for the record.
Good morning, I'm Mang Wu Vang.
Thank you.
Yeah, the image I took I took it on top of the hill. Was it, what's the road? West Murray Creek, the image I took. So I was taking the image from on top of the hill to get
So
my
the question
image.
is, does this from an aerial perspective look like your, what is it, 6.9 acre property?
I'm sorry.
Assuming you took it from about this area towards the trees right there. So you would agree that's the property that you're saying is the proposed grow site?
Yes.
Can you explain why we can't see any of these 100-gallon smart pots in there right at these times?
Yes,
Other than, it looks like there might be something right there.
Yep, the center right there, that's my water tank. That's why I, started my cultivation back in April. So I have receipts to provide and to prove to you guys. And the center there, that's my water tank. And my property there, I hired people to, clean up the brushes. So now you see all that area is cleaned up. So I started way in April. And like I said, I can prove receipts and paperwork, date stamped. And I don't understand why the image can't catch my pots, my soil.
When did you buy the pots?
Like I said, in late April.
You have receipts for the pots?
Yes, I do.
You didn't submit them?
Not at the time when I did my application, because I didn't know that I need receipts, but I do have now. I do have it with me.
You want to get them?
Yeah, I have those.
He wants to get those receipts. Can you give him a moment?
If you can answer one more question while you're looking for your receipts, how many gallons is that water tank?
2,500.
2,500.
Yes.
It says that on the receipt.
All right. I didn't recall this.
He's saying on the 30th, these pots were there. That's it? And that's May 31st.
Go ahead and hand it to her, and she'll hand them down. Thank you.
Now, I have a couple questions too. Did you move these pots at any time between April 30 and June 3rd?
No.
Do you have a grow site at any other location other than on this 6.96
No, I
acre
don't.
parcel?
No, I don't. It's just, like I said, I hired people to move all the brushes, so
And when was that you did that?
in mid-April.
Mid-April?
Yes. And my receipts there, like I said, I bought it in late April already, all my supplies and water tanks.
What do they call these pots on the receipt?
They are wire mesh.
Wire mesh?
Wire meshes.
And where did you buy them from?
Meeks.
Meeks.
Right. Should be one of those receipts.
don't see it. Now, Mr. Vang, looking at the photograph, the aerial, did you say that little dot in the center of that cleared area, that's your water tank?
Yes, it is.
Okay. And where were your plants located with respect to that?
In the same area, right in the same area. That's why I don't understand. You guys can't see my pots. And when I went to the planning department, I told them, is there date stamped evidence on the Google image? They couldn't provide me, and it's not, you know. So that's the one answer I'm concerned to. So it's not date stamped, so.
Well,
they
we
can
have
always-
one now that is, May 31, and it shows the same thing.
Okay, right. But at that time event, I asked them, can you prove me the date stamp? And,
I
yeah,
understand that, but we
Right.
now have a May 31 date stamped, that, and you can't see any pots in it
From Google Earth.
from Google Earth.
It's a,
Right.
and it's showing the same image.
How wide are
within a
these
few days
pots?
difference.
How wide are these pots?
how wide?
Yeah.
Right now, they're you know, they're big, but
No, I mean the pots themselves.
how big is the pots?
Yeah, the pots themselves.
They're by 4 feet radius.
4 feet across?
Yes.
The ones with the smart pots or whatever they're called, wire mesh.
Are you renting this property?
Yes, I am.
How long have you been renting it?
Just this year, beginning of this year, early April.
So you were buying supplies for this property before the
Yes.
current owner?
Yes. The owner was just here, he left, but I can always call him.
And
come
he
back.
bought it in April, late April?
I'm sorry?
He bought it in late April?
He's been owning these properties for a long time, for 10 years.
The recording date for purchase was in 4/25/2016. Your
Yes.
receipts predate his purchase.
Those were the receipts that I bought, and I immediately started working, hired employees, so we did move things fast and did work in a fast pace because the deadline was coming up, so I was concerned.
So where were you storing this stuff while he was purchasing the property?
I don't think he said that he was purchasing, that the owner was purchasing the property. The owner's Michael Fouch, and he's had that property for years.
So I have a question while you're looking at the receipts. In the photographs with the 6 rows of plants, where's the well in relationship to those photos?
I do not have a well. I don't have a well, so
What is that you said was in the middle of
Storage
your...
tank, water
water
storage tank.
tank.
So where's the storage tank in relationship to,
It's in the same area. I just left it in the same area.
in the same, like in, to the,
It's
The north,
towards
the south?
it's right in front of, yep, right there.
I don't know, I can make it in trouble.
so it's like right in that corner right there, where the
So the
truck or
previous
that
owner's
white,
married.
Yes.
whatever that is.
Yes.
Uh-huh.
So that was the very first thing I went and bought because I don't have no well. So I bought the water tank to store my water.
Right.
So I was concerned
So
about
the
water.
water tank is really clear in the aerial photo, and
Yes.
it's very close to where these plants are, and yet they're not, there's no evidence of any plants at all. So even in terms of the scale, I know a water tank's much bigger, but still, it's, you would think, there would be some contrast, right? Just the soil, is darker, the plants.
The image that we took in late May, early June, and although we didn't have the exact date at the time that Mr. Vang came to the office. The attachment in your file has the date. It was taken on June 3rd. We were able to extract that information from the metadata. Clearly, we'll show these kinds of pots. We can't see them here. We don't have any. I was looking through the rest of the files to see if we had any that showed them. But if you look at those aerial imaging, you can clearly see where pots lined up in rows like this are visible. I think they're half a meter. I can't remember the terminology, but the resolution is a half a meter, and so that's about 1.5 feet. Clearly, that would show up on any of the imaging that we have.
Especially, I mean, maybe it was one plant, but there's a mass, so that's going to be looking like
You would
a-
clearly see,
Yeah.
rows of the
Right.
pots.
I see evidence of pots, but I don't see any evidence of marijuana.
Well, at this point in time,
this
the
point in
plants
time,
may not
that's-
be, but the ordinance allows for the preparation of the site,
Right.
knowing it was early in the season and plants weren't necessarily in the ground on May 10th.
Okay.
But the ordinance said that, cultivation or preparation of the site for cultivation. But the concern that we have here is that these pictures do not appear to represent the site.
So,
And we denied the application based on the misrepresentation of these photographs. There's nothing that demonstrates that these photographs relate to the site that he's applied for.
so it appears that, do we have a copy of the lease?
Yes,
What's the date on that?
the date, it starts April 1st, 2016, and it was signed,
Who was the landowner?
yes. Oh, no, he wasn't the landowner on April 1st.
No,
Oh, Mike.
So it appears that he took possession of the property on April 25th,
April 21st, right?
the landowner. But he wrote a lease on April 1st?
For April 1st, but it was signed April 30th. However, where the April 30th was signed, it seems to be whited out and the 30th replaced that.
Okay, so if he took possession of the property on April 25th, that's the legal date he could have rented the property, and in 5 days, between April 25th and April 30th, we put those pots in and filled them and laid it out? I'm just,
I don't
Well, and
think
also
that there's evidence there that Mr. Fauch got title to the property April 25th. He's had it for years.
okay. So still, if the lease started April 1st, that means in 25 days, that garden turned into that quick. And it couldn't have because the receipts are dated the 20th, so in 10 days, it still would have had to be presented to look like those pictures.
Well, and the brush cleared as well.
Yeah.
And a question, what is the size of the water storage?
2,500.
2,500, it's probably 10-foot wide radius. It's a big tank.
10-foot radius?
Yes.
Okay. And what would be the radius of those pots?
3 to 4.
Okay.
Yeah.
Well,
Just to give you an
that's
idea.
good.
Yes, so you see a big difference
What are you
between
talking
the water
Right,
tank
but
and
you-
my pots.
But you talk about a lot of pots, not just one, but a lot.
And where's the water tank in the middle of these pots?
It's right off to the, if you look at their, it's like right supposedly here, if you can see that, like off into this left corner.
That blue, okay.
By that white, by the vehicle
Okay.
and the tent. Or
By the
truck
red.
and the tent.
Because I blow it up and I can see red next to it.
Any other questions?
Yes. Did you say you don't have a well on this property?
I do not.
Where do you get your water?
I order water.
You do what?
I buy water.
A truck comes?
Yes, from tanks, yes.
And do you know where the truck gets its water?
I'm sorry?
Do you know where the truck gets its water?
Where?
Yeah.
He owns a ranch. He owns hundreds of acres around my property that I'm leasing from. So he says he has permission from the county, so he gets water from his property.
He gets it from CCWD, you're saying, because the county does not provide water.
Right. So that's what he says. Yeah, so I'm believing what he tells me.
At $10 per.
Well, it could be pumping up from a surface source. We don't know where it's coming from.
No, we don't know.
Well, the ordinance requires the registration application contain a description of the legal water source that will be used for irrigation of the medical cannabis. Do we know what that description was here?
Not sure. Do we have a description of the legal water source? Are you guys looking at that?
Hello?
Commissioner Wooster was saying part of the ordinance requires a description of the legal water source.
State certified water delivery service.
That's the name of a company? State
Yes.
certified water service?
And I don't believe it's the name of a company, I think that's what it says. Yeah, that's the water source.
Is state
The state
certified water?
That would be CCWD, one of their fill stations,
Or
or
CPUD?
or CPUD, or whichever. I mean, that could just be
Happen to hire-
anything. Could be anything.
Peter, I believe you have to have a valid permit through the Environmental Management Agency to be an authorized individual to provide water via water truck. I believe there's some indication there from both the state and the county that you have to have a permit to do that. There's some kind of authorization that has to be done.
There would be state requirements for the sale of water, whether it's agricultural or domestic. And I think we need to investigate this further if the appeal were to be approved to determine whether or not this,
Is a
the water supply
Right.
meets the criteria.
He did mention he does have a permit.
Okay.
He is authorized to get water,
Okay.
yes.
Are there any other questions of Mr. Vang right now?
Not right now.
We may have some more later. Thank you. Is there anyone else with us that would like to address the Planning Commission on this appeal?
My name's Michael Falvey. I live in Mountain Ranch on West Murray Creek Road. Addressing the water source, I'll leave it at this. Mr. Wooster knows where the vast majority of water that goes up West Murray Creek, he knows the ranch it comes off of. I'll leave it at that. And he can investigate personally if he wants to. It's up to you. It's not a water entity, a public water entity. Whether it's permitted or not, I don't know. But the water trucks go up and down West Murray Creek all day long. Since the fire, I can see now from my house down to West Murray Creek, right at the three-way intersection, if you're familiar with it. And it's pretty much all day, and into the night, I might add, that water trucks go up and down the road, and a rough estimate on my part is probably 90% of them come off of this one water source. So I'll leave it at that. Number two, I was in the survey business for about 30 years, and I dealt with, I don't know how many hundreds and hundreds and hundreds of aerial photographs. And in the case of this parcel, the picture of the parcel, if you had 4-foot diameter rows of pots, it would look like a black magic marker line going through the photograph. 53 of them, yeah, they're going to stick out like a sore thumb. And if they are around that water tank, it looks to me like they were maybe a lot closer to some vegetation than they might be represented in this photograph here. Where's all that brush that's I don't see any indication of brush that close in the aerial photograph, so. But again, they should stick out like you drew a black line on the photograph. Thank you.
Thank you.
My name is Michael Stone, and relevant to this appeal, I own 040 024, 07, and 08. If you had a map that shows you this parcel 01, I own two much larger parcels on either side of that. So the only thing that this parcel touches that isn't bordering my land is West Murray Creek Road. The owner of that parcel, I believe, is Mr. or Ms. F-O-U-X. And there may be some rental or lease agreement with Mr. Vang. I know nothing about that. The owner may own hundreds of acres in Montana or someplace, but not up there, because my parcel 7 is 168 acres, which is basically east of that, and 68 acres, number 8, which is west of that. So my concerns are that a grow in that neighborhood renders my much larger parcels, in my opinion, basically without value, unsaleable, and because of the nature of a marijuana grow. Secondly, related, ability to get a loan to do improvements. I've been saving for years to try to do some development up there, and I'm concerned that the banks might not lend if they knew that there was a marijuana grow immediately adjacent to what I was trying to get a loan to develop. Number 3, water. The gentleman may have a tank, and God bless him for putting one up there. We need a lot more of them. I don't know where he's going to get the water to put in it. There is a 30-some-odd-year-old capped well on parcel 5 that hasn't been active in many years, but there's nothing on 1 or 7 or 8. The runoff comes off of 7 on my hillside down into the low spot on 8. It's seasonal. By mid-April to mid-May, whatever water's down in there is gone. So when he needed it most, July, August, and September, there's no water up there at all. An ag well would render the existing domestic wells dry. And somebody like me that wants to put a domestic well in for a small house might find themselves having to go deeper and deeper and deeper to get any water at all, even if we could. So I don't know if they're planning on trucking in water or what the game plan is. That's part of the discussion I haven't been privy to. The last concern I want to raise is I spent 29 years as a deputy DA, and I think that there are security concerns about having a grow, especially in the back areas, on back roads. There is a non-approved road that's been there for at least 40 years. I've used it to get to the backside of my property. The other owners north of me use it to get to what amounts to the south end of their properties. Somebody has a gate at the north end of my number 8. It runs right through the middle of parcel number 1. So they may want to litigate whether or not they want to allow people to have access, but folks have been using it for much longer than 20 years. And I think a lot of the neighbors might have concern about that. I first heard about this with a letter from the planning department that was dated the 9th of September and post-stamped to me on the 12th. This is the first I've heard of this. I do not recall the date that I actually looked at parcel number 1 last. Well, when it's been since the fire, obviously. I don't know the dates, but there were no pots, there was no tank, and there was no indication that anybody was trying to do a development, and nobody has contacted me. Any questions?
I don't think so. Thank you.
Thank you.
Anyone
I'm
else?
hard of hearing, so. Thank you.
Thank you.
Thank you. Anyone else? Okay.
The deed was granted to Michael Felch by Robert G. Merrick, trustee of the Merrick Residency, on April 25th, 2016. The lease was started April 1st, 2016, and it was signed April 30th, 2016.
So as Lisa said, the lease was
Excuse me.
signed before
Can I-
title to the...
Can I ask him to speak into the mic? The gentleman that just spoke isn't able to hear him.
Okay.
Thank you.
So what you're saying is that the lease was signed prior to possession, legal possession of the property?
The lease was started prior.
But
Yeah, it was signed on the 30th, but it commenced prior to possession.
Correct, and the date of the 30th seems to have been altered. There's why that altered.
Okay, but I just want to point out, in looking at it further, I believe that the Merrick Trust is Michael Fouch. So it could be that he just did a transfer of some sort.
Okay.
So I think we're okay on that.
Thank you.
I was looking at it.
Anyone else? Okay, Mr. Vang or Mr. Weisberg, did you have any further discussion or presentation for the council?
Nothing further.
Okay. All right, then I'm going to close the public hearing and bring it back to the commission for discussion.
Well, it seems to me that the planning director has made it clear that pots of the size and number that are shown on the application would show up in an aerial photograph, and Mr. Falvey has confirmed that same fact. And they don't show up, and there's no explanation as to why they don't show up. As to the water, Mr. Falvey gives me credit for more knowledge than I have. I may have some suspicions about where this water is coming from, but I don't know. But it does seem to me that there is a reason for requiring a description of the legal water source that's going to be used for irrigation, and I'm not convinced that we have that. And if this urgency ordinance was designed to allow people to grow marijuana and just grab water wherever they can and haul it in on the truck however they want, it certainly doesn't seem to be written that way. Legal water source has to mean something, other than just you go fill a truck wherever you can and then take it out to a site.
I just wanted to make one brief statement to the commission. Because the appeal was not denied based on water source, the application has not actually been fully vetted. That is something that wouldn't be looked at by planning until, if the planning commission were to send it back for further processing, that's when it would be considered. So I think that I would ask the planning commission to base its decision on the evidence presented today.
Well, I would think we would do that. So I'm in favor of denying the appeal.
I hand off to Lisa for right now.
Okay, based on the denial at 95165N3A, is reading through it, looking at the lease, looking at the lease, I could understand with the starting on the 1st. The issue that I'm taking is that the pictures were taken on April 30th. The receipts show purchases and deliveries about the 21st to the 27th, which makes me struggle with how you could buy the purchase, that equipment, and in 5 days have a farm that looks like that. I don't think the pictures are relative to the Google imagery that we're looking at. So based on that, I'm going to uphold the planning department's decision.
Okay.
Yes, I also am going to uphold the planning director's decision without any further comment.
And I would say I don't believe the photos represent the site, and the aerial imagery, I am confident, would show what the photos depict we would be able to see in this aerial imagery even from the June 6th Google map. I think it was June 6th.
One other point on this, and it comes up time and again, is this ordinance requires that the registrant provide evidence satisfactory to the planning director that these things have been proven. And it's pretty clear that didn't happen. And I can't find any fault with the planning director's decision.
I would agree with that. Anything to add, or should we look for a motion?
I'll make a motion to uphold the planning department's decision.
Second.
It's been moved in second, and all in favor say aye.
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 Motion carries 5-0. Okay, thank you.
So,
Shall we go for another one?
yeah, let's do, 'cause
Yeah. Okay. So we're going to continue on to 2016-1059, appeal of 2016-482, denial of commercial cannabis cultivation registration application for APN 014-030-006. And this is Gina.
Okay, you have before you some late correspondence that showed up via email on September 20th. I do believe it was sent to each and every one of you, but I'm uncertain as to whether or not you received it. I'm going to for you. It was just sent in by Sean Hollingshead, which had some concerns regarding the activity on the property. States that he wasn't able to be here at the meeting and wanted to express his concerns over a number of issues. One happens to be, apparently he's indicating that there isn't a power pole on the site, no well, septic, or any other structure. He also goes on to note that there's employees living in a travel trailer, in addition to a couple generators, which doesn't appear to be causing him too much concern because he doesn't think they're excessive ordinance. However, it's mentioned in his letter to us. In addition to, he indicates that there is, noise. He goes on to say, until the creek is dried up, there was pumping from water from the creek known as Pennsylvania Gulch. And he also has some concerns with where individuals are disposing of human waste, since there is no, according to him, which has not been verified, an on-site septic system on the property. So given that, we'll just move on. So again, this is an appeal of the denial of the Planning Commission, Planning Department / Director's denial of a registration for cannabis, commercial cannabis cultivation. We denied the registration based on a few things, one of which was no lawful possession of the property prior to May 10th, inadequate evidence of cultivation prior to May 10th, in addition to no legal water source on the subject property. So we'll address the lawful possession issue right now. As we all know by now, urgency ordinance requires individuals to demonstrate that they have lawful possession of the property prior to May 10th, or you have to provide a lease agreement that shows that you were on the property prior to May 10th. So the grantee that was submitted with the registration is actually granting title to the registrant, which is also the co-landowner, in addition to one other person. And that grant deed didn't record until May 11th. So they didn't take ownership over the property until May 11th, which is obviously after the May 10th deadline. Evidence of cultivation prior to May 10th. So what we have here is actually two adjacent parcels, both owned by the same individuals. However, only one of which was registered for cultivation. 143006 was the parcel that they registered. And that, I apologize, I probably should have put a larger photo in there. But it's the parcel that is shown to the right, the larger parcel shown to the right. With the caption, it says registration cultivation site 2016-482. So what they registered for was a 22,000 square foot outdoor cultivation site. As of May 10th, there is no evidence of cultivation on that subject property. And there was no evidence of development of the site for the purpose of cultivation. When in fact the actual cultivation is taking place on the adjacent parcel, and they did submit a site plan with the registration that clearly demonstrated their intent to relocate the grow that you see to the left over to the parcel that is located on the right. Again, they are two separate legal parcels. However, they did not register the current site that is being cultivated upon. The current cultivation that you see is only 8,785 square feet, keeping in mind that they registered for a total of 22,000 square feet on the adjacent parcel. And again, the site plan was very clear. There was no intent to hide anything. It was very obvious that they had intended to relocate that grow from the parcel located on the left to the parcel located on the right. However, according to the urgency ordinance, relocating that grow is not in compliance with those regulations. In fact, they could actually resolve this issue if they wanted to do a lot line adjustment to merge those two parcels, but again, they would not be allowed to expand that cultivation. If they did merge the two parcels, they would be able to pull that cultivation outside that 75-foot setback where it currently exists. But again, given the fact that there's already another issue with the title of the property and obtaining ownership, I don't see that that's really going to gain them anything at this point. So the next issue is a legal water source. The application itself actually indicated that their source of legal water was from surface water from an unnamed creek, and not really having seen any other registration calling out, irrigation from an unnamed creek. It started to cause some concerns with us as to whether or not that was an actual legal source of water. When I spoke to the applicant regarding the situation, he indicated to me that he had a riparian right to use that water. So I thought, well, I'll do a little investigating and try to find out, whether or not this riparian right exists. What does he have a legal right to? So in a nutshell, water rights are very complicated. You can have riparian rights, appropriative rights, prescriptive rights, but what it comes down to is that the California Water Resource Control Board says whether or not you have the right to use that water. And as of right now, we have no evidence from that agency that indicates that the applicant has obtained that right to use that surface water from the unnamed creek. As a matter of fact, I had some email correspondence with that agency, and they had nothing registered for the under that applicant's name at that location. So until we get evidence of such, I would say there is no source of legal water. So very basically, in conclusion, based on the failure to comply with the urgency ordinance, the registrant does not have legal possession of the property prior to May 10th. There was no evidence of cultivation on the parcel that was registered prior to May 10th, and we do not find any evidence of the legal water source for the irrigation of their cultivation site. So again, as you've heard before, CEQA does not apply to projects that are rejected or disapproved. And Planning Department is asking you to sign a resolution denying the appeal.
Any questions of Gina?
Yes. This deed is dated March 28th, and the signature is notarized March 29th,
Correct,
but not recorded until May 11th.
correct.
Okay. Legal counsel can correct me if I'm wrong, but I think that a deed can be effective between the grantor and grantee when it's signed, notarized, and delivered,
That's correct.
even if it's not recorded. Is there anything in the file that indicates what the delivery date was
The delivery date
of the deed from the grantor?
the recorder's office, no, the recorder's office just indicated that they record deeds the same day that they get them. When I questioned them about the length of time in between, the signatures that appeared on the deed versus when they actually recorded it, I guess it could be a number of reasons. One was indicated to me there may be an issue with, securing finances for the property. But in fact, what we have historically been going by is the recorded date on the actual document, and nothing other than that. But that would be up to your determination.
The date that they are given the grant deed is the official date. The recording is noticed to the world, but he technically owned a grant deed on that March date.
If it's delivered.
Yeah, yes.
That's true, but coming full circle, the ordinance says the registrant must provide either a recorded deed proving the registrant's ownership of the parcel prior to May 10th. The recorded deed by itself doesn't prove that, does it? Because it doesn't show the delivery date. And so I think you're correct that he didn't show lawful possession prior to May 10th.
That he did
Not.
Did not. Did not. No, okay, so we have evidence of cultivation on APN 1430-003, but that's within the 75 feet of the eastern boundary of the adjoining parcel, right?
Correct.
But both those parcels are owned by the same person.
They're both owned by the same person. The cultivation is clearly and identified in the application as well. That is currently located within the 75-foot setback. And that was the intent of their relocation, which would be in fact compliant with the ordinance if that was all one parcel. But in fact, it's a separate legal parcel. And as I said before, if we didn't find any other issues with this, they could indeed dissolve that boundary line or adjust the boundary line to accommodate that setback. However, they wouldn't be allowed to expand upon what they're currently cultivating, which is, far from the registered 22,000 square feet.
So the ordinance requires a 70-foot setback from any property line.
75 feet from any property line, even if it's an interior property line between two parcels that you currently own.
Okay, that was my question, because it's not obvious to me why it would require that if the same person owns both parcels.
Exactly, but that's the way it's written. But like I said, this particular situation could be resolved with a subsequent permit or application, but I don't know that we can get them there based on the other issues with the application.
Well, as the application sat on June 30th, there was no application for a grow on parcel number 3, correct? Only for parcel 6.
Yes,
And as of that date, there was no evidence of grading or cultivation on 6.
correct.
Okay,
As a
thank you.
matter of fact, we received a grading permit dated September 2nd from the September 2nd or the 3rd from the Public Works Department illustrating a very nice site plan and the intent to grade parcel 6 for the purpose of relocating that site. So it's unfortunate, I guess, that the ordinance was written the way it was, and that this particular applicant was abiding by the law in that he didn't go grade before he got his permit. But it's just the way the ordinance is written, that it doesn't give us the authority to allow him to relocate the grow to a separate parcel.
Okay, thank you.
I would agree that's unfortunate, but let's move on to the water rights. So you did contact the State Water Resources Control Board.
Yes.
And there's no evidence of any permit or any such thing for a riparian water rights.
Correct.
And that's what the said applicant for the registration said it was, riparian water rights.
Right.
But that's not what's stated within the application for registration.
Well,
That was
surface
what they,
water-
surface water of unknown.
Right, so the riparian right would give you the right to use water, surface water from a waterway that actually traverses through your property or touches your property. In fact, if this Pennsylvania, and I'm not certain that this letter from Mr. Hollingshead is even correct. I don't know. The applicant is saying unnamed creek. I do believe there was a couple blue line, or some indication of some creeks that were touching the property down towards the southern portion of the property. I don't know if I have that in here. I don't really know where they're taking it from, but until the water board says you have the right to do it, or provide us with evidence that I suppose I don't have any evidence that indicates that they have the right to use that even for agricultural purposes.
I'll save the rest of that question later for the applicant.
Any other questions of Gina right now? No, so is the appellant or the appellant's agent, is it Orozco?
Orozco, yes. I'm Chris Williams. I believe I have an appeal here you can grant. I think there's several errors in your conclusions. The first one, we were on the right track and then we got off of it. The law considers you to be in ownership of a piece of property when you've received a grant deed. A grant deed has been signed over to you and it's been delivered. This grant deed was signed on March 29th, and then it went to the escrow. Now, I consider that delivered. I consider the escrow office is an agent for the buyer and the seller. The escrow closed on the 4th. So for some reason, I don't know what, the escrow people did not get that to the recorder's office until the 11th. But to me, that is inconsequential. The recording requirement is to give notice to the public. It doesn't make ownership. Ownership is exactly what Commissioner Worcester first said, and I believe all those elements were satisfied. In addition, I would give you a letter from the previous owner. I think there's enough copies there for the commissioners and the council. That Mr. Orozco had authority, permission to occupy the property before he bought it. I don't think that is really necessary, but because he owned it. So that is a legal conclusion that I think you have made a mistake on. It's not the recording. The second issue about inadequate evidence, I think, again, we've got several issues, but Laura Hall, the environmental consultant, will come up and speak too, but the grow area really straddles the boundary line between the two properties. And I think, again,
and we've talked about this before, and I'm going to give you something on it for your further review. These overlays, these property line boundaries can be wrong, and you can consult your own GIS people. They will tell you they can be wrong. But she has seen the grow area, and it straddles the line. There's about 8,600, 9,000 square feet of grow on the 06 side, I believe. What Mr. Orozco wanted to do, because of the 75-foot setback, was to move those 75 feet on 03 over, proportionally in proportion to 006. And he should be able to do that, but they have not allowed any grading permits to be issued. On this question of the inaccuracy of boundary lines and how I think you're going to see applicant after applicant coming in here saying, well, these pictures aren't right. But this is an appeal that I've taken to the Board of Supervisors of your decision in another case of mine on this issue of boundary lines. And if you look at pages 3 and 4, you'll see an explanation in there, which I think that the Commission at least has the responsibility to check with its GIS staff and to run this issue by, because I think if you don't, your decisions become arbitrary and capricious. We have told you that your maps are wrong, and you have just said, we think our maps are right. They're not right. The one thing that Ms. Cathan said, and I agree with her, I think this can be fixed by a boundary line adjustment because we've got the same owner of the two parcels, and we can solve the other two problems. The first one is the ownership issue, and the second one that we have to worry about is the water rights issue. And again, you reached a very wrong conclusion on that. I read all the correspondence. I read what the state board wrote to the planning department, and it was misinterpreted by the planning department. I practice water rights, and in a riparian right applies and attaches to land which abuts a watercourse. So someone who has a piece of land that abuts a watercourse can put their pump in there, and they can withdraw what's necessary, reasonable domestic use, reasonable and beneficial domestic use. And that right is correlative with everybody else who has a piece of property on that stream. Everybody can put a pipe in there, and they can pull out a reasonable amount of water. They do not have to have a permit for that. They do not have to have a license for that. What they are asked to do, and I don't even think there's any penalty if they don't do it, is they have to file a statement of diversion and use. In this case, an initial statement of diversion and use. And that isn't even due, that doesn't have to be filed until July of the year after you begin the use. Now, I think they've already filed that, but the ramification of not filing those statements and recording your use is that you may be disadvantaged in the future in terms of your relative priority with other people because they didn't know about it, you can't prove it, you haven't been filing any proof of the water right. But they don't need a permit. They don't need no stinking badge. They don't need that permit to utilize a water right here. So that issue should go away. I strongly believe the ownership issue should go away. I mean, what are we trying to do here? Are we going to say that the key word is recorded? The key issue is ownership, and he owned it. And then it's the issue of where the crops are located. And I think that's great. Give us the opportunity to do a boundary line adjustment.
We have a lot of questions. Go ahead, Kel.
With respect to the lawful possession issue, the ordinance requires that the registrant must provide a recorded deed proving the registrant's ownership of the parcel prior to May 10th. And I agree with you that it doesn't have to be recorded to be effective. But the problem I have is, if this ordinance means that the required proof has to come from the recorded deed, this one doesn't do it because it doesn't show the date of delivery, as deeds normally do not. And we don't have any other evidence in the file of when there was a delivery. And the delivery to escrow, it seems to me, is conditional upon an escrow closing. And so that's the problem I have there. With respect to the water right issue, I think you said that you can withdraw water from a riparian source for reasonable domestic use. Is that correct?
Yes, which includes agricultural use. And this is agriculture.
Well, this is a commercial license, right?
I also just want to remind the Planning Commission that there are findings made by the Board of Supervisors in the urgency ordinance that suggest an intent to not treat the marijuana cultivation as agriculture. So I would ask the Planning Commission to review the urgency ordinance and develop its own interpretation of whether that was the board's intent.
Okay. That's all the questions I have.
Well, Commissioner, I have to differ with you. I think the purpose was in wanting to show that you had ownership. Recording doesn't make ownership. The key word is not recorded. I mean, I know I've argued with you all before about you're going to have to do some interpretation. You just can't apply the strict letter of the regulation, and the purpose was that you show ownership. So he has a letter, or occupancy. He has a letter there from the previous owner saying he was allowed to occupy the property as early as the previous October. He has a deed that was executed the 29th, escrow closed on the 4th of May, and as I say, I mean, you know, you're in the real estate business. Sometimes a title company gets the thing over there the same day, sometimes they don't. But when the escrow is closed, that's it. He's the owner. He's the owner. In terms of this water right thing, I mean, I was surprised to hear the discussion that we're now questioning whether water that is put in a tank, a holding tank, is legal water. There'll go a whole lot more applications if that's not legal water. I mean, CPUD is passing an ordinance, an updated ordinance on bulk water sales. CCWD is doing that. They can go and buy water. There's different restrictions if you're saying it's potable water and it's going to be used by a human or not. Then you have to license the trucks, the vendors. But I never heard the notion that that's not going to be considered legal water. Riparian rights is legal water. You don't have to have a permit or a license. You just have to exercise reasonable, beneficial, domestic use. So I would ask that you take those solutions for those two problems and then allow, in terms of this boundary issue of whether it's on 6 or whether it's on 3, let him merge it into one parcel, and then that problem goes away.
Are you done, Kelly? Mm-hmm. I can understand the area and the confusion for ownership satisfied. The boundary line adjustments, yes, I do believe that could solve the situation. But when you brought up earlier the GIS thing being off and it putting it in the middle of the grow, it's still within 70 feet of the boundary line, whether the person owns both properties on both sides regardless. But a boundary line adjustment can solve that problem. So I want to move on to the water rights. Surface water, riparian. Can we demonstrate which creek on there is the water source that you're claiming?
Well, let me say this.
Please.
Usually the way, if you're forced to prove a riparian right, if you're forced to prove it,
No,
you have to demonstrate that you own the parcel that abuts the stream and that that those riparian rights were never separated from that parcel of land. In other words, if he's using it on 6, he can use it on 6.
When we get to it, Chris, but please explain to me what you're getting.
I'll have him explain to you where he pulls it from,
Okay.
because I haven't seen a map of where he pulls it
Okay.
from. All I've seen is the words unknown and unnamed creek.
Right.
But
I believe there's a lot of unnamed creeks up there. Creeks. Sorry. I did not mean to say that. But unnamed creeks up there, and that do flow. But I do have a point to get to. Can you please demonstrate what this unnamed creek is? Because there are definitely creeks.
Yes, sir. Here's a.
And could you please state your name for the record?
My name is Jose Carlos Orozco.
Thank you.
You can see this is the 10-acre lot. This is the 2.5-acre lot. The yellow dot indicates our point of diversion where we're getting the water from.
Okay.
Yes. wanna look at
Maybe
it?
you could pass that up.
It's up on the screen.
Yeah,
Oh, okay.
it's right there.
The yellow dot is where?
Give him your, can you,
It's right here.
well then put that on the.
Again, the
so
map
other
up there
people
looks really
can see.
poor compared to the map that we got.
Is the name of this creek Pennsylvania Gulch?
When we looked at it on the GPS marker, this is Lauren Hall.
Laura Hall, actually. I visited the site and I did his water permit. We just turned it in September 6th. It wasn't due until next year. You all should have an email from the water board stating that my client is in compliance, that it wasn't due until before January of next year. His lawyer was supposed to forward that email to all of you. And they are also come to the county to talk to the county about this issue. And they said to bring up this particular project, and they'd be happy to discuss it with you.
I'm sorry,
Okay, so you're, what's your name again?
Laura Hall.
And what are your credentials?
I'm an environmental planner, and I permit cannabis farms and do water rights.
Okay, let's move on. So you just sent in this to the State Water Resources Control Board, what
Yeah.
date?
September 6th, but it wasn't due
September 6th.
until
So
next.
you have had a reply from the State Water Resources Control Board since September 6th, verifying that everything you said was correct.
Yes, right there it is.
It's a letter from them about this certain case.
So when you did these things, were you able to demonstrate that as year-round water source? That
No,
it flows
no.
year-round?
No, it does not flow.
It does
year-
not flow year-round,
No, it does not.
So
but
is
he's-
that a reliable water source that you can demonstrate to the State Water Resources Control Board
Well,
as a
he-
year-round reliable water source that you're being provided with?
Well, it's
the
not
water?
year-round.
So
He
is
can-
it dry right now?
I don't know. I haven't been up there.
It's not dry right now.
But the thing with the creek is, in the North State, there are lots of cannabis farmers that use surface water. It's not common here, but it is a common practice, and he has the riparian right to use that surface water.
I'm
He
not
can-
arguing the riparian right
Yeah.
as so much as the ability to demonstrate that that's a year-round water source that you're going to be collecting your water from.
Well, I don't know if it's a year-round creek, but he can store that water in the winter and use it in the summer. Right now, he's not storing that water, but in the future, we were going to submit this reporting of water and storage. They want you to report a year after so they can see how much you use. That's why it's reported a year following from the use.
And also on the plan, whenever we turned in our application, we also turned in the plans of us storing water in the wintertime to use in the summertime for the same reason, that just in case that creek doesn't run all year, you know, we are
So
legally
that was
allowed to store that water also.
Part of what you turned into the state was your storage area.
Not storage, because he's not storing right yet, and he doesn't.
On the new proposed site though, we were gonna be storing, we haven't got there, but on the plans, the sheet should have in the thing, it should show drawings of storage containers in our new proposed site. Because that's what the water board wants you to do. They want you to store in the winter months, so you don't have to suck out in the summer months, so.
You're talking about diverting water from a creek to store during the winter that's not permitted by the State Water Resources Control Board on storing.
It is, I just have to report it when I do it. I haven't did it yet, so I don't have to report it yet.
If you read the email, that's discussed in the email.
And also the water board, I think, has a
I do need to
meeting.
finish reading the email, so.
Well, it says that they'll process the initial statement after checking to make sure that all required information has been submitted. They're not saying anybody has rights, they're saying they'll look at the application.
Excuse me, I'm sorry. He will discuss that with you when he comes. That's true. That's not, I thought that was listed in there. But he is going to be here on the 28th, a gentleman that wrote this email, and he's going to meet with the county and discuss water rights.
So he's not currently impounding any water?
No, he's, I could. Oh, there's more, yeah.
I'm confused by the premise that, is there a requirement in there that says you must demonstrate a year-round reliable source of water? I mean, people are growing, you see what season is.
Here's where I'm going with it, Chris, is it doesn't state in the urgency ordinance that you need a year-round thing of water, but for a reliable water source as per the State Water Resources Control Board, which is the regulatory agency that the urgency ordinance directs you to, they do have rights and how it pertains to year-round water sources and diversion. And holding of diversion from.
There are rules as to what you can store under a riparian right. That is correct.
Yes.
But I don't know why that's relevant.
If I just may, I would like to just briefly counsel the Planning Commission again. I think we've talked before about statutory construction. In this case, the first duty of the Planning Commission is to review the language of the ordinance and determine whether or not it is adequately plain. If the Planning Commission determines that a word or phrase, etc., is capable of being interpreted in more than one way, at that point, the concern of the Planning Commission needs to be what the Board of Supervisors' intent is likely to be in having drafted the language. So that's how statutory interpretation works. So when it comes to the requirement of the water right, the Planning Commission should be looking at the language in the ordinance regarding the water right and determining whether or not that's plain or whether there needs to be further interpretation of the board's intent. With regard to the word recorded, the Planning Commission also needs to look at that word, determine if it's plain, and if not, determine the Board of Supervisors' intent. I would also remind the Planning Commission again, I know Mr. Williams has brought up before that he believes that the county has a duty to affirmatively prove boundary lines because he asserts that the maps are inaccurate. It is the appellant that has the burden of proof at these proceedings.
So I would like to ask if we can go to lunch, have a little bit of time to read through this ordinance so that we can specifically focus on that language.
It's been a proposal to recess for lunch. Is Kelly shaking his head? Ted?
Yes.
Yeah, okay. So we're going to take a lunch recess and reconvene and come back to this discussion, and we will be back at 1:15. There you go.